They were very quiet.
I know, yep, I'm turning them up a little bit.
Okay.
Yeah.
Yes, I had failed to give you the 72-hour notice. I was going to do the
Okay.
online, and
Yes.
that's why I came in person today. But I just wanted to make sure that's still the provision we're
Yes.
working under from the bylaws. Is
It
it possible to give you a 72-hour notice?
Yes.
Okay.
It is. And
Right.
if you can, if you want to tell me the last meeting, like some people do.
Well, the challenge is more. I mean, I could say I'm going to be here, but sent to I know what's going on.
I got you.
Something like that.
I understand.
I would
Okay.
say it'd be one of those deals where you just say, hey, I probably won't be here at the next one. Then if you show up, there's no harm, no foul.
Right.
Thank you.
Let's do roll call. I'm going to start from my left.
Bruce Johnson, Alder Prep, Dayton, Ohio.
Annette Ludd, Toledo representative.
Brian Honan, OOD Legal.
Lindsay McKinney, BE Training Manager. Christy Howe, BE Program Manager.
Orville Sharp, the Area Manager.
Would you like me to go over who's on the phone?
Yes.
Okay,
Oh, and I'm Yvette Shackler. Zanesville Rep, OVRC Chair. I'm sorry.
We have Frank Bergassa.
Okay, thank
Dave
you.
Bergassa, Chris Sabin, Mark Messick, Keith Jermel, and Dean Hamilton.
Great. Oh, I have a question. Hello?
Hello.
Somebody had a
Yeah, Chris. It's Chris.
It is, sir. It is. Let me go on mute.
You okay, Chris?
Yes, I am.
Okay. Let's get started with.
Did you have a question? Did you have a question?
Somebody had a question?
Yeah, Chris, what'd you need?
No, it's not related. I was talking to an IRA agent. The link wouldn't load, and I had to go into an IRA session to get it resolved.
Okay.
So that's what was happening.
Let's do the, I forget which order I'm in here.
In your minute.
Let's do the approval of the, anybody have any objections to the minutes from our last special meeting, the March 13th meeting? We do. I'm sorry, I'm all out of it. One thing goes wrong in it. The minutes first, and then we do the public
Right. Yeah.
comment. Yes.
Yeah, you're good.
Anybody got any objections? We're going to the minutes from our March 13th meeting. Hearing no objections, it will be approved without objection. Let's do any public comment. Anybody receive anything for public comment? Yes, hearing none. Let's get started with Rule 14. Annette?
All right. Rule 14, informal resolution, grievance, and arbitration. OOD establishes this rule to satisfy the requirement of affording a fair hearing to licensees as required by 20 U.S.C. 172.B6 and 34 CFR 305.13 in effect on the effective date of this rule. Let someone work into that one. All right. A licensee dissatisfied with any BSVI action arising from the operation or administration of the BE program, including employment decisions and ministerial decisions, is encouraged but not required to first attempt a pre-grievance meeting with the assigned area manager to resolve any issue. Then we have another paragraph, which is kind of weird here. It says, BE shall schedule an informal meeting within 30 days of receiving the written request. This request for informal resolution is not a grievance. Should we have that as a separate paragraph?
I just think it's very confusing. Both
It is very confusing.
I also think that I think it's a given that if you're dissatisfied, you talk to, I don't know. We added that in. There's not really a pre-grievance meetings, that they're not tracked. I don't think they happen. We added that to the last rule. I mean, I understand the point, but And I guess it's okay, but I think that they should totally be separate. That VE scheduled informal meeting should be a separate
I
letter.
agree. That's what I'm saying. I don't like them together.
Or should that just be C?
But is that, I get no finesse.
They're kind of independent
Is
of each other.
Okay, yeah, no,
So the first step is to file the grievance.
No,
No.
the first step is, this thing says you can talk to somebody,
Okay,
which I think does happen.
yeah,
Yeah.
yeah.
I doubt there's many people that get mad and just jump right to grievance. They usually will pick up the phone and call and yell at Orville or something.
Why me?
I think that scheduling 30 days needs to be well below. I think that if you go on, I think that needs to be well below. It's kind of ahead of than the C.
Okay, well, let me repeat this, because maybe I'm not following.
Okay. Satisfied with the operations administration of the VE program, including encouragement are required to first attempt a pre-grievance meeting. The issue.
Okay, B is, get a pre-dash
Mhm.
grievance meeting. And then what did you say, Chrissy? C?
So, like,
Well-
then it says, then we should schedule an informal, but then it goes into a licensee may file a grievance or request a fair hearing when the licensee is dissatisfied with any BSBI action arising from the operation or administration of VE. 1, the request shall be made in writing and submitted to the VE manager. 2, the request shall be received by the VE manager within 365 calendar days of the date the licensee became or reasonably should have become aware of the action taken. Engaging in informal resolution shall not extend this time frame for the operator to file grievance. 3, no grievance requesting a fair hearing shall be permitted concerning employment decisions, ministerial decisions made by OOD, BSBI, or B, a denial does not prevent the operator or licensee from requesting an arbitration proceeding pursuant 34-395-13 in the effect. And then it goes D, whenever a licensee files a grievance in accordance with Ohio law and this rule, VE shall schedule and conduct a fair hearing pursuant to the 119. And then it talks about the fair hearing. But I think that first you have a conversation with an area manager or whatnot. Then it says file a written grievance. Then VE shall schedule an informal
Yes.
meeting within 30 days. So I think that C needs to be separated from B and down after they file the actual grievance.
I agree. Yeah, that it's
Yeah.
kind of like that someone just plopped it right there. It doesn't even have a letter or nothing. It's just
And
plopped
Madam
there
Chair,
to be there. Dave was requesting the.
Okay, so,
Madam Chair,
yes.
Dave is,
I'm sorry, Dave. I'm sorry. Go ahead, Dave.
this is completely contradictory. In the opening paragraph, it said a licensee could file a grievance for any reason, including employment decisions. And then, what is this, C3? Yeah, C3 says no grievance requesting a fair hearing shall be permitted concerning employment decisions or ministerial decisions. So,
Madam
that's
Chair,
completely
it's not-
contradictory.
Yes, and that,
It's not contradictory in that the first place where it mentions it, it's just griping about it. You're calling and complaining and wanting to talk about it. The second part is the actual grievance. So even though I never liked this part, and I agree with Dave that I never liked that it should be in there, but they're two different things. One's just an informal, before you file a grievance, you can call and talk to them about anything. Or meet with them and talk to them about anything before the grievance, including ministerials and employment stuff. But they only will take a grievance on things that are everything but ministerial and employment. So they don't contradict one another, but I never liked it anyway. I'm with you,
The
David,
what,
that
though?
part.
With respect, the way it's written sounds contradictory.
And which one are you on? You on A,
B.
B, B,
I'm talking about C3.
C3?
As opposed to the.
So C3's in there, and the ministerial, we've talked about this, and employment, because we're a state agency and it's governed by civil service rules and unions and all of that, that's why, you guys can't read decisions that are relating to employment. That's the reason and the logic. I know no one likes it, but and it's always been in there.
Well, first of all,
Staff
Yeah.
hiring, staff hiring decisions,
Discipline,
yeah.
discipline,
right.
Right.
And maybe job description related
Yeah.
stuff, who's gonna.
classification, that's, yes.
No,
Madam
yeah,
Chair?
Go ahead.
the problem I have with it, first of all, it's not always been in there. It's been in there the last couple of rule packages, but it's not always been in there. Second of all, those things, correct, hiring and
Right.
discipline and all that, I get. Where I have the problem with it is that it has been used for very much operator-related things, such as assignment of a consultant to a particular operator. That's been told, well, that's an employment issue, so you can't grieve that. Well, I don't believe that. It has nothing to do with the union or anything. That has to do with, and it does go one-on-one with how an operator works with a consultant. So I understand why it's here. What I don't like is how it's been used and interpreted.
I agree
Madam
with
Chair,
that.
I agree with that.
Yes, Frank.
So, again,
I was going to say,
go on,
I was
Frank.
going to say, I was going to say I agree with what Annette's saying, and no, it hasn't always been there. It has, like Annette said, it's been there the past few rules packages, and I think it is way open to, well, in some ways it's open to interpretation, in other ways it's not. And I will just say this for the record: if we have an operator and a consultant that aren't working well together, and if the program can find a way to fix and rectify that, then I would think they would want to do it so that, they have an operator and a consultant that can work well together. And I think most of the time, consultants and operators work well together, but every once in a while people run into a personality conflict or this or that. I don't know what it would be, but we should be able to resolve those internally without getting into having to go down the road of a grievance or go down the road of, some big dispute or anything without it turning into something it doesn't need to be. Thank you.
Go ahead, Christy. He was trying to say something.
Right now, with the exception of Columbus, every region has one consultant. So, and I've always been told, that we can't allow an outside entity to make assignments. So that's why I think it's been in there. But
Should it be where, I don't know if it should be here in this section.
Chris, I want to.
Go ahead.
Is it Brian or Brian?
Brian,
Brian.
Brian, thank you. Brian, I have a question for you. The use of this word ministerial as opposed to administrative decisions. To me, when I look up ministerial, because it wasn't a term that I'm familiar with very much, it refers to routine acts of government rather, or clergy, and that's right. Routine acts of government or clergy versus that are conducted in a prescribed manner. Meaning that that the use of this word implies that the decisions are somewhat pro forma to a given set of guidelines that exist to guide the decision making process. Versus administrative decisions, I think, are a little bit more subjective to the discretion of the administrator based on what they believe is in the best interest of the entity, of the government entity. Do I have that distinction accurate in your familiarity with it, with administrative law? Is that accurate? Because I'm wondering whether the term ministerial decisions is the right word to use here or not.
I think, well, it could be both words would be able to be used in there. Ministerial decisions certainly should stay, right? Ministerial, you wouldn't be able to grieve those because that is basically, you are right about the interpretation of the difference in those words, is my understanding anyways, right? I don't know how it was understood. I didn't write the rule. I wasn't involved in any of the rule package updates. I don't know the specifics of what definition they're using.
But to me, the question of whether something's grievable would boil down to whether it was routine based on a prescribed set of policies, which gets us back to policy manual.
Yeah. Matt.
Or if it wasn't routine based on a prescribed set of policies and it was more a subjective administrative decision, that would be grievable.
I don't necessarily agree with that.
Right.
There are certain subjective administrative decisions that don't involve operators or that are something that's just up to the discretion of the BE program.
If they didn't solve the operator wouldn't have any standing for grievance.
Madam,
1 second.
I can help with this,
Go
I
ahead.
think. But there is a definition in our rule for ministerial decision. It's in Rule 1 DD. Means a decision which has no material impact on the nature, quality, or quantity of service provided to BE licensees and will not adversely impact opportunities for licensees.
Okay.
Madam Chair.
Yes.
So ministerial, like our requirement to pay bills on time, how we pay bills, using, OAPS and PIN and all of that, the 3-bid process. That's the stuff that, like if you guys wanted to say, I disagree with how you have to get 3 bids. Well, that's a ministerial decision because we are required by DAS to do it that way.
Okay.
And so that's what, using salvage and going through that process, that's.
Or how operators are paid for training. And that's something
That's discussed within this group. I wouldn't consider that ministerial. Or how.
No, I'm not saying the wage.
process.
I'm not saying the
Okay,
wage. I'm
the
saying
process.
saying the warrant check versus the direct deposit.
That we need an invoice, that we need, yes.
Right.
Yes.
So that would be considered ministerial.
Yeah.
Administrative is
That's where I get a little confused. And I think like
the difference.
Annette read the definition, and again,
Well, that's the definition for ministerial.
ministerial. We don't have a ministerial.
No, we don't.
And I think it would confuse it if we added another definition.
Yeah.
I think we need to get back to where do we put this 30-day written request?
Madam Chair.
Yes, Frank.
Frank. I just had a question for Christy because I've ran into this before, not recently. It's been a while. We had an operator in Cincinnati at one time that was trying to get their security cameras. This is a while back, probably before Christy was here. And the consultant kept, they were trying to get the bids, but they were only getting one. And then I had to get a hold of an area manager and find out, well, they explained to me, no, we can do it with one out of the bid, but we have to solicit 3. But if only one comes in, then we are able to get that equipment. So I'm just saying internally,
That's
as a
correct.
program, we need to make sure that's communicated to probably operators and consultants so that everybody's on the same page there. It got straightened out, but it was a little confusing. So and it was just, I think it was an internal thing
That's
that.
correct.
Yeah, because I was told that, and this was a while back when I was at the SEC, they have to have 3.
You have to solicit 3. If
Okay.
2 come back no bid, we have to solicit 3.
Madam Chair?
Yes,
The problem with the definition of that, and I never really thought about the 3 thing, and I had the 3 soliciting, and I know the Bureau has to do that. That does go against it could be interpreted going against this definition, though, because it says, adversely impacting the quality, quantity, and adversely impacting an operator. Sometimes if you have to wait for bids and someone could argue that adversely
That's
impacts
exactly,
an operator.
and that's exactly what it did.
So I get the Bureau has to do it, but that doesn't kind of go along in tune with the definition that's here.
Yeah, because that's exactly what it did. It was
So we can't bypass the
You can't.
procurement rules.
No, we understand that.
That's a ministerial decision.
And,
Yeah, first group.
and one thing that has been looked at is like if we could get in trouble if like every single business goes to Schaefer without giving other companies opportunities.
Right.
Like that looks.
Well,
Contract.
I understand that. I just want to make sure that
Been agreed.
a consultant would know, you know,
Yes.
it's a reasonable period of time. Okay,
Yeah.
we don't have any
Yeah.
other things. Let's get moving because
Right.
I mean this was held up for months. If I'm dealing with, you know.
And normally they do not hold up for months. We
Okay.
get quotes very fast, and maybe that was a different time or a
Right.
specific consultant.
Yes.
But that's where, again, having concerns, going to the area manager, they can absolutely resolve that rather fast.
Okay.
But Madam Chair, two
Yes.
things. One, I do think, back to Christie's point, we need to move the one statement
Okay, so
down.
we're trying to figure out moving it
It
down.
needs to go down under C somewhere.
Yeah, like after they filed the grievance.
Yes.
So after a licensee may file a grievance and request a fare when the license, should that be number one? No. Then they request, the request shall be made in writing. The request shall be received by the BE manager within 365. No grievance, 3. And then I think that it should go after maybe
Yeah, number
4. Should it be 4 or should it be D? Should it be
I think D is separate thing because it's a step.
D?
Because A, 1, 2, and 3 tells about what you can grieve and how you grieve and all that. But then D starts with whenever a licensee files a grievance in accordance with Ohio law, and this will be shall schedule and conduct a fair hearing. Well, prior to the fair hearing
Right.
is the informal.
Yeah.
So that should be D, and then this should be E. Yeah.
Okay.
Hold on.
But Madam Chair, I'm not done with
Yeah.
the employment issue thing though.
Okay.
We need to go. I don't want to overlook that. So
You can go ahead.
I was going to say we need to. I think we all do understand it's not up to an operator to be able to grieve hiring, discipline, pay rate, all the stuff that the unions control. But I still don't like the idea that has been misinterpreted. Like I said, when an operator has an assigned consultant that they, for some reason, clash with, and it's just not working out, and the operator requests that they work with a different consultant, that has been used as, well, you cannot grieve that because it's an employment issue.
So, and here's why. Here's why. When someone posts for a position in like Dayton or Cincinnati, that is their post, that is their region.
Mm-hmm.
If we reassign someone that is in there to another region, they can then grieve, and they would have a grievable union on civil service with OOD in the state, that they're being reassigned to a different region. And so that's where we get that contradiction thing where why we have to, we can't, I can't easily reassign someone without going through legal, or not legal, HR, and saying, hey, we want a change of region, we want a change of assignment. All of that has to go through HR, because then they would have agreements.
Yeah, but Madam Chair, it's been done a lot. I know we've had consultants from Cincinnati who were assigned to people in Columbus. I know Tanya worked with Jim for a while, for example.
Because of holes and people off. Again, I'm not saying that we can't work on it. I'm saying, though, that if someone's not happy with their operator, can they grieve that, or their consultant, can they grieve that and demand, and would the actual result of that grievance be a reassignment, and would that contradict our civil service rules with HR?
Well,
Well, let's look at it the other way, Madam Chair. If a
Yes.
consultant has a problem with an operator, say the operator is inappropriate toward them, or there's some issue like that going on, can the consultant request to have a change? Because I think we've had that happen too, where they said, hey, this operator has not, I can't work with them, and we've had it changed. So if it can work one way for a reassignment, why couldn't it work the other?
well, wouldn't a solution be that this is when the area manager, in those special circumstances, because we don't have it happen all the time,
No,
where the area manager can kind of work to be the conduit? I mean, I know that's not, there, but
I think so. All I'm saying is that I don't think it can be a grievable issue on your guys' part, but that doesn't mean we can't have conversations and work it out. I've known of one time where I have reassigned a consultant because of misbehavior by the operator, but again, it was in an area where there was 2 other consultants.
okay.
Yeah, scale of the program made it easier when you have more.
Right, we had 2
Specialists
in
per-
Dayton, 2
yeah.
in Cincinnati, you had, yeah, and again, I
Madam
can't
Chair.
get,
Is that Dave?
yeah.
Dave, go ahead.
Annette is right. This can't be filed under a ministerial decision because it does impact the quality and service to operators. You can't defend against one potential grievance from an employee by trying to block grievances from operators.
but it's an employment decision.
It's not a ministerial.
It's not.
It's
That's
not an
what it's saying.
employment decision.
It is an employment decision. Assignment is an absolute employment
So-
decision.
So what you're saying, if the consultant acts to be changed,
Reassigned. And I denied
Reassigned.
that
You
those
can do
grievances
that.
have been denied.
Okay.
Because they were employment decisions.
okay,
But if a consultant came to you
and act,
and asked and said, hey, I just can't work with this operator, it's toxic,
You're
you
saying,
would change.
I would not change it automatically. I think conversations would happen because, again, I don't have that ability to do that without consulting HR because they're based on regions, they're based on what they applied the job to be. And I've had some consultants come to me, well, I don't get along with so-and-so. Well, tough. I mean, you have to work with what you signed up for. There are always going to be people that you don't get along with, whatnot. I can't willy-nilly put a consultant in Cleveland. That's not how we set this up to work with someone that's in Cincinnati. Now, yes, on short-term things, when people have been out on leave, when we've had a vacancy in Cleveland, Kelsey's been covering Cleveland, we've had people cover areas in a temporary situation, but permanent assignment, people picking and choosing who they want, that is a employment decision that I'm telling you guys right now is beyond even me. They're under OCSEA union. We have 2 unions with OOD, and our consultants are under the OCSEA union, and so they have union rights.
But
Madam
Chair,
Chair, their union rights would not basically specify what area of the state they work in.
They absolutely do. It's on the posting when they post for the position. It absolutely is.
and I believe, actually, I remember we talked about that. I think Chrissy told me that is the way they have it set up.
But Madam Chair,
yes,
what
ma'am.
recourse does an operator have if they do the right thing and they're working and they're saying, hey, this consultant is not doing what they're supposed to be doing. I just can't work with them, or I feel threatened by them, or it's toxic working with them. Those type of things. And they've come to the area manager, they've come to Christie, and they can't get it changed. What recourse does an operator have at that point?
Sure, they can come to us. We would, again, have to follow our HR rules. We would do an investigation. I'd work with labor. We would have interviews with that consultant, and then they would be disciplined under the disciplinary grid of OOD and the state. That's the recourse. That's the recourse.
But
That's-
but
Madam
at the end
Chair.
of the day, not necessarily removed. It depends on.
It would depend on the
what
investigation and the findings, that's right. And again, we can't dictate how you guys discipline your employees either. It's the same way. I can't go and say, hey, and we've had this situation where a great operator, his employee flipped off someone in a car that had, and it was reported. And all we can do is say, hey, and we've had this happen on a number of occasions where we've gone to operators and said, there's been a complaint on one of your employees. You need to address it. I can't tell them how to address it. I can't tell them you need to fire them. I can just say, you need to address this. Just like you guys, if there's an issue with my staff, you need to bring it to an area manager or me, and we are obligated to address it. But I've also had consultants that I'm not getting every little thing I'm asking for, so therefore I want a new consultant. I've had that happen too, and I'm like, it doesn't work that way either. Let's, again, talk this through.
So what we're changing here is we're going to take. You said you're going to move that down to E.
To D, B shall schedule an informal meeting within 30 days of receiving a written request. This request for informal resolution is not a grievance. I don't understand. What does that, oh, I understand, is not, the informal is not.
I think that's to differentiate why the two sections, as was it Dave that says they contradict each other. It's further explaining why they can.
But can't,
Because you can bring up an employment or a ministerial decision for the informal part, but you can't bring it up for a grievance, and that's why it says the formal part isn't a grievance.
Can I flip something in here?
can we take that sentence off, because I think it's confusing. This request for informal resolution is not a grievance.
Well, I think that the B was where it was for the right reason, which was A was you can ask for the meeting, and B is how do you schedule that meeting with the area manager.
No, two different meetings. B was before you file a grievance, talk to the area manager, and then file a grievance, and then a informal
But
meeting scheduled.
But to talk to the area manager presumably was a scheduled meeting.
No, it's separate. That's the area manager is not the informal. The informal has to happen with the program manager.
Well, I looked there at the time of scrap. So.
Well, one of the things that you don't get the informal without the grievance.
Right. That's it. Yes.
Wait,
Correct.
So
I was looking at the first one, B.
I
It says
hate
this
B.
isn't a grievance. But in
I
B,
hate B. B was a combination. B, that add-on, and that's right, that add-on, and B was brand new last rule package, before you do a grievance. And then what conflated it was B shall schedule an informal meeting within 30 days. That kind of, okay, you haven't even filed the grievance yet. You just had a conversation with the area manager. Then you file the grievance,
Yes.
then you do the informal.
Why don't we, in order to allay confusion,
Yes.
take out B?
I'm all for that.
Get rid of this whole, that you can talk to that doesn't need to be, and we can talk to the
Yes.
manager. Why does it need to be, because it says it's, it's not required, it's encouraged, but not required, that doesn't need to be in.
Well, I think you do want to.
isn't that at the end of A though?
No, that's
No.
B.
that's B.
Okay.
So, and we take that out,
Yeah.
and then move right into a licensee may file a grievance and request a fair hearing when the licensee is dissatisfied. Go right into that. And then put this, like we said, this,
I'm sorry.
Okay. Get rid of B, this whole encourage to talk to the area manager.
That would be a given.
That's a given. I don't know that it needs to be in the
It's
rule.
under, is that under B?
Yes.
Let's say that.
A is this whole gobbledygook
Okay.
about, the establishing the
That's fine,
rules
yeah.
and I think it's.
But then you still
Well,
have
it
to
cites
move,
the-
you still have to move
Yeah.
the formal down after they file. So does that become D, or is C still C1, 2, 3, and then D is B shall schedule an informal
I think
meeting?
that's how it should be.
And then can I take out this request for informal resolution is not a grievance, because I don't think that
I don't
makes
think
any
that-
sense.
Yeah, I
Are
think
you talking about the part that says B?
Yeah.
Yeah.
If you're deleting B, you would be deleting all of it.
No.
No,
We're
it's
going to
separate.
move the this BE shall schedule an informal meeting within 30 days of receiving the written request.
Yeah.
That's period. That's we're going to take that sentence and move it and make it what will be C, because C is now going to be B. So,
So C will be B,
yes.
and then what we in schedule.
And then we're going to schedule
Is that
that'll become, the B will be now a licensee may file a grievance,
Mhm.
and then it goes into what can be a grievance, all of that stuff. Then the next sentence will be after it tells you what can be a grievance and how to file it. BE shall schedule an informal meeting within 30 days of receiving the
And that'll
written
be C.
request. But it probably should say why we're rescheduling in an attempt to, it probably should be more than just that thing. In an attempt to try to resolve the grievance.
Madam Chair, that's already in E.
Yes.
That's already in
Well, then
section
why
E.
is this?
Section E is the informal meeting after
Yeah.
the grievance is filed.
Oh.
Section B is the informal meeting scheduled pre-grievance.
And I hated that.
Well, that's
And
stupid.
So if you're getting rid of B, you get rid of
Get
all
rid
of
of
it.
all that. You're
Because
right.
the 30-day scheduling is already in section E.
Yeah,
which is
You're
much
right. It
bigger.
is. It's right there. Yep.
So removing B and
Get rid of all of B then.
That was my confusion.
Okay, I see that now.
Okay. So C will be B. That will move up.
Yes.
Hold on. Hold on.
While the grievance is pending, the BE manager or designee shall contact the licensee to determine if the grievance may be resolved informally. Any informal meeting shall be scheduled within 30 calendar days of receipt of the grievance. Yeah, this is all here. What the heck did we put B there for?
Yeah.
B is
And I
for
thought it
the
was always
informal
confusing.
before filing.
Yeah, that's,
Yeah.
yeah, we don't need that.
And my track changes did not work.
The BE manager or designee shall provide a written summary of any informal meeting to the license. Yeah, this is all good stuff here.
That's why the informal meeting in B, where it says that last part of the sentence where it says this informal meeting is not a grievance.
Yes,
Because
okay.
That's outside of the grievance
It
process.
is.
That's pre-grievance.
Yeah,
So,
let's get rid of that. Though,
It's
because,
confusing.
yeah, it is.
just want to delete all of B.
Yep.
Just we have to
That's why the B, the whole thing of
All
B
of B,
is
yeah. All of B.
because everything else is already in E.
Right.
Hold on.
I don't think so. I think he's
Okay.
still in there.
I don't know which one is his.
He is the 8737.
Ah, okay.
They are supposed to, but sometimes in discussing rules.
Okay, what's the next? So everything else moves up, right?
Yes.
Yes, yes,
So C will now be B.
yes.
And B will be C.
Mm-hmm.
All right, so I still don't like the employment thing.
Which one you don't like in that?
The employment thing. I'd love to find a solution to that.
Well, I think temporarily until we can come up with something else, I think that's where in our area managers
But
trying to work through every issue.
And unfortunately, I think it's a little bit subject to interpretation because selections are employment-related decisions that are grievable. And so, it's ambiguous. You could say, employment decisions of OOD staff or some sort of a clarifying phrase there that would speak to the fact that it's OOD staff employment decisions that are not grievable rather than employment decisions related to operator or facility assignment. Yeah, because that to me, that is also an employment, it could be interpreted as an employment decision.
OOD staff aren't employees.
Right, OOD staff,
Or, operators are employees.
right, we're not employees of the agency, but,
Right.
But it is,
I see what you're saying.
our
but-
employment is subject to a selection decision. which is agreeable decision.
Yes, Madam Chair, Chris is right. That could be interpreted that way.
If
That
something,
an employment, I mean, it should say OOD staff employment decision. No, because Chris is absolutely right. That even though we're not employees, our employment is a decision that is made and,
And-
could, and is obviously, I mean, you are allowed to, I think everyone would agree, you are allowed to grieve a selection.
Madam Chair,
but it says the now, yes or
will Chrissy just come back in? Chris, can you repeat that?
Essentially, what I'm saying is the phrase employment decisions is somewhat ambiguous or subject to interpretation because a selection decision, while not an OOD staff employment decision, is still an employment decision for the operator. It relates to their employment in the facility or not. Even though they're not so-called employees of the state, it's still the means by which they make their livelihood. And so what I'm suggesting is just putting a phrase in like OOD staff employment decisions. Rather than just the naked phrase employment decision.
Madam Chair,
yes.
it does say, before that though, it says operation or administrative of the BE program,
Oh.
including employment decisions and ministerial decisions. So I think that kind of covers
Yeah,
it.
I kind of.
It's always been
Yeah, I
staff,
consider that
OOD staff. It's never been about
Yeah.
operators.
But that's
But
B, and we're getting rid of that anyway.
It's a ministerial decisions made by OOD.
Oh, got you back.
Yeah.
That's what.
yes, but
Uh-huh.
Madam Chair, Chris is right. I could see, say a selection goes awry, and there's a big old blow up. We had them before,
Mhm.
and somebody grieves it, and the bureau says, "Oh, gee," behind closed doors, they're saying, "Yeah, we messed this one up, but hey, we can." I'm not saying you guys would do this, but others would have. They say, "Hey, I know how we can get rid of this. If this guy agrees, we'll just say it was an employment decision and stonewall him." Not accept agreement.
For them making a decision in their own facility?
No, a selection. A selection could be interpreted as an employment
I've
decision.
always interpreted that as being
You
a staff.
Well, can I,
Yeah.
Madam Chair,
Yes.
this is Brian.
Yes,
Sorry.
Brian.
It specifically says, no grievance shall be permitted concerning employment decisions or ministerial decisions made by OOD,
It does.
BSBI, or BE. And selections are made by a local selection panel
Yes.
by vote. They're not made by OOD, BSBI, or BE. Those are,
Yeah.
so an employment, that's, even if you say a selection is an employment decision, that's an employment decision made by a local selection panel, which
Yep.
includes members of OVRC. So
Yep.
that's not,
Yep.
you couldn't interpret it as that.
What about a temp?
What?
Or how long, I mean, there's several things that BSVI decides and in conjunction with a local committee sometimes and this and that. But that do impact the employment of an operator. What Chris is saying is right. I'm not saying you guys would do that, but it could be interpreted that an employment decision of an operator is ungrievable.
I'm not reading it that way in that. I'm trying
Well, I don't
to follow you.
I don't see why, for purposes of clarity, there's any problem with inserting the phrase OOD staff.
I don't either.
To me, it just adds clarity
Yep.
and does not in any way constrain the agency toward anything that Christie would argue is not the intent of the rule in the first place.
But Chris, you don't see that I'm saying ministerial? It has that word in there. So
Ministerial is a routine decision
But it's
that's guided by
referring to-
policy.
Yeah, but it's referring to the BE staff. I mean, you think it's just the word staff needs to be there?
Well, actually, it's saying and.
No
Ministerial.
grievance requesting a fair hearing shall be permitted concerning employment decisions or ministerial decisions made by OOD, BSVI, or BE.
So, but or tells you those are two separate things, Eva.
Okay.
Or employment decisions is one. Ministerial decisions, routine administrative decisions guided by policy is another.
Yes.
And so we're saying in the case of employment decisions, it would just be simple to put in OOD OOD staff employment decisions.
And ministerial decision though.
Or ministerial decisions would still be what it's always been, which is routine, guided by policy. This is the thing, guided by policy.
Guided by policy isn't in the rule.
I know, but the definition of ministerial includes
It's not in our rule. The definition of ministerial decision in our rule doesn't say guided by policy. It just says it's a decision that has no material impact on the nature, quality, or quantity of service provided by BE licensees and will not adversely impact opportunity. It doesn't say guided by rule. Typically, that is usually ministerial decisions are guided by rule or guided by some sort of internal policy or something, but that is not the definition in our rule. I just want to be clear.
So you wanted to say no grievance request in a fair hearing shall be permitted concerning OOD staff employment decisions or ministerial decisions made by OOD, BSBI, or BE.
check.
Yes.
Okay, done.
That's what they brought that.
Done.
And I just think that is clarity. And it will help you. It will help you too in terms of
I think Frank was one of
giving
the-
operators who might bring agreements a more clear boundary.
And again, at the end of it, it also says the denial does not prevent the operator or licensee from requesting an arbitration proceeding. So you might have a denied grievance, but you can still take it to arbitration.
Madam Chair,
No.
Frank was wanting the floor.
Oh, hold on. Who was that?
Frank.
Frank, go ahead. I'm sorry.
okay. My only concern here, and I understand what ministerial means, I get it, but at the same time, and I'm not saying this would happen on Christie's watch or Director Miller's watch, but over time people change and things change. And my only concern here is what if they try and say something something is a ministerial decision when we all know in fact it's not. That's where this could become problematic, I would think, for the operator or even for the committee if we were trying to sort through something like that. And yeah, I know they're not going to take it out, but I was just trying to figure out a way to make this a little, I don't even know if there is a way to make it a little bit more balanced. I understand ministerial decision, I get it, but at the same time, I want to make sure that we are able to advocate for a vendor or operator in our role as the OVRC representatives and alternates to make sure that things are being done correctly. And if they say it is one, it for sure is one. And I don't know the solution, but I just wanted to put it out there for everybody to think about. Thank you.
Madam Chair, I know the solution. I would grieve that decision. I would turn around and write a grievance. If they said, okay, if I grieve something, and they said that's a ministerial decision, we're not accepting your grievance, I would turn around and grieve that and say your decision that this was a ministerial grievance is not a ministerial decision. You obviously came up with this. It's not an everyday, that has no impact. I would turn around and grieve that.
And Madam Chair.
Dave.
I think we have to revisit what Annette was saying earlier in that operators have no recourse for something like this, trying to shove everything under the ministerial umbrella. One potential solution, I think, would be to take the ministerial word out of this. The ministerial decision would still be there, and OOD could argue something is a ministerial decision, but I think trying to prevent operators from grieving something that is legitimately grievable, I think that's contrary to the spirit of the rules in general.
So again, people cannot grieve procurement. They can't grieve our processes, even though that they might not agree with it. They can't grieve right now that, again, they're requiring everyone to go to EFT and to go to the payee portal and all of this. That's beyond even OOD. And they're providing, it's stuff like that.
If I could grieve you buying USI equipment, I would.
Hold on. Well, I was put in this. I've had this experience wherein I filed a grievance at the SEC, and my grievance was denied. It had nothing to do with ministerial, and this is why we went outside because we couldn't even follow the process of filing. the grievance. The grievance wasn't even heard. I mean, wouldn't even be recognized that we filed a grievance.
Madam Chair, they
Yes.
went through a period of time a few years ago. Actually, they've done it a few times over the years where they took this spell of throwing grievances in the trash and coming up with an excuse not to hear it by declaring something was ministerial or declaring it was an employment decision or something. That hasn't happened in a little bit, but it has happened a few times in the past, which is why everyone's kind of, a little briskly over this rule because it has been abused.
But,
in
Madam
the
Chair,
Yes.
find another state that it's 365 days. Most states it's 14, 7, you gotta grieve. We have 365
That's a
days.
good thing.
So
Madam Chair,
we're not gonna relent on the,
One second.
we're not gonna be permitted to relent on the ministerial because of the protections of all these other procurement stuff and employment and all of that we have to follow that an operator might disagree with.
Okay, let me ask.
And Dave wanted the floor, then.
Okay, go ahead, Dave.
it's not really you can't really tout having a very long grievance period when there's things that you should be able to grieve, but the rule says you can't. That's not a plus for operators at all.
Let me ask you this. If you're grieving something that's concerning your facility or something that happened with your location or whatever, how can that grievance be denied? If it has nothing to do with staff, has to do with, like, for example, which we don't pay anymore, but, whatever issues that has to do with your facility, or something to that degree, how can those grievances be denied if it hasn't?
The only thing that I could see where those could ever be denied is if it was an issue that people were well aware of that was beyond 365 days. That's where I think where legal looks at those to see whether they fall under rules or not. They look at two-pronged. Is it within the time frame, and is it a ministerial or a OOD employment issue? Those are the two times that it could be denied.
Well,
I don't think anything else could be denied, and I don't see where it has been denied.
Well, when
last
things
10
have
years.
changed, let me just ask you this, if things in the time period, you said we have 365 days, well, what if conditions change, something's changed, such as we used to pay? I'm just trying to figure this out. If something's changed that now, but the Bureau did not make the changes timely to whatever the operator's giving, how is we're bound to it? I don't know if you guys understand. Let me give you an example. Well, remember when we used to pay set aside? I'm just using this example, Christy. When we used to pay set aside, DSCC was commission, and DSCC was still paying commission. Okay, when the state and everyone else has stopped paying commission, and then we turned around and we was continuing. So we filed the grievance to stop us having to pay because we were continually having to pay, and we were told that we weren't timely. But before that, you all had the decision. That's why the state folks stopped paying commission, but we never stopped it across the board at that time.
And I think we got to the board when another case came out or when it went to the case. That starts
The one in Derrick.
Yeah, that starts the clock again, and so then it is grievable at that point in time.
That's
Madam Chair?
yes.
From Christie's mouth to God's ears, because that's not how it's always been interpreted.
Mm-hmm.
For example, and I'll just make up one here.
Mm-hmm.
New person bids on a rest area. Not a new operator necessarily, but someone bids on a rest area. Their first rest area, first time ever running a canal. And they come in and they grieve the fact that there's only allowable of 6 vending machines. Okay, that's something I don't think anyone would call ministerial. I don't think they would say it's an employment decision. But what I would think they could say is, This BGA was signed over 365 days ago, so now you can't grieve it. That's the type of things that was being done before. They would try and find some ruling that happened or some decision that happened before the time period and apply it to that particular situation.
See, and I think now we would absolutely accept that grievance and show where did we break the rule and show us,
I would interpret it as outside of 365 days. It's a new operator, so it's asked to that operator.
And
They can't be bound.
I applaud that. But I'm telling you what the type of things that have been done in the past. That's the type of things that were used to, put grievances in, in the circular file cabinet.
but then, and then you could grieve the fact that it was denied. I mean,
We did that.
So
There was a bunch of operators that grieved the fact that grievances were being
and then
denied.
there's always that caveat too, that just because your grievance wasn't accepted doesn't mean you can't take this to an arbitration.
But-
So there are safeguards.
There are, and there are some.
But you can't take something to arbitration if your grievance, you don't follow the grievance process.
Yes and no. Yes and no.
They make you follow
I think if it was denied, then you absolutely can. If someone doesn't file a grievance and go straight to arbitration, then I think RSA kicks that back and says you got to follow your internal process. But if you're an operator and you say, I did file it and it was denied by the state, that's a different circumstance. They would take that up.
And I'm sure there have been times when the states have denied a fair hearing based on an interpretation, and someone took it to arbitration and they kicked it back and told the state, shame on you. You should have offered this person a hearing. That actually has happened. In the past. So there are some safeguards. I grant that. I'm just saying how these things have been abused in the past. And
But I can see that basically being a big waste of time because the state's going to come up with a fair hearing decision that supports their point of view, in which case you're going to go through the arbitration process anyway. So all the feds did is kick the can down the road because they're going to end up here in the arbitration. Anyway.
Juan is coming in.
Hola. Like that shirt,
Let's make sure we're all following it, make sure if the keep order, let's make sure everybody goes to their chairs. Keep order. Where are we at in that?
We're still in Rule 14.
No, I'm saying, where are we at in rule, where do we stop off at? What letter are we on?
We've bounced around quite a bit. So
That's fine.
we can let's go to what is currently C. A license, we'll just go over the process real quick here. A licensee may file a grievance and request a fair hearing when the licensee is dissatisfied with any BSVI action arising from the operation or administration of the BE program. The request shall be made in writing and submitted to the BE manager. The request shall be received by the BE manager within 365 calendar days of the date the licensee became or reasonably should have become aware of the action taken. Engaging in formal resolution shall not extend this time frame for the operator to file a grievance. No grievance requesting a fair hearing shall be permitted concerning employment decisions, and we added the BE staff employment decision, or ministerial decisions made by OOD, BSVI, or BE. The denial does not prevent the operator or licensee from requesting an arbitration proceeding pursuant to 34 CFR 395, effect on the effective date of this rule. Whenever a licensee files a grievance in accordance with Ohio law and this rule, BE shall schedule and conduct a fair hearing pursuant to Chapter 119 of the Revised Code where such provisions do not conflict with the Randolph-Shepard Act as amended and the following requirements. And that's a weird sentence there, but just the way it's worded, but I know what it means. But BE shall schedule the fair hearing within 60 calendar days of receiving the grievance. The fair hearing shall be conducted by an impartial hearing officer under contract with OOD. All right, the fair hearing shall be held in person at the OOD central office in Columbus, Ohio, or through an OOD approved video conference software with the consent of the impartial hearing officer and the parties. Any person participating in a hearing may appear remotely through an OOD approved video conference software. Any person participating remotely shall ensure compatibility and connectivity with the OOD approved video conference software prior to the start of the hearing. Proposed exhibits shall be exchanged between the parties and the hearing officer prior to the start of the hearing. Anyone good with all that? All right.
I think you might want to put a timeline on how far before the start of the hearing. I don't think Brian would appreciate it if somebody dropped an inch-thick stack of documents on his table as the hearing was about to begin.
To be fair, that's exactly what you're allowed to do under Chapter 119. And just without boring people with war stories, I used to do Chapter 119 hearings a lot when I was at the Attorney General's office, and that absolutely was the common practice. And that someone would dump a giant stack of exhibits on your desk 5 minutes before
they're trying to basically render you unprepared for what's about to come.
It is absolutely allowed. Hearing officers can change that at their discretion and can say, I want, we have particular hearing officers that will say, you have to exchange exhibits within 15 days before. Yeah,
okay.
We do that. Most of the time our hearing officers will do that, but they are not required to under Chapter 119.
And
that is common.
And the hearing officer.
Sorry, Madam Chair, I forgot to address you first.
No, you're fine.
Madam Chair, the hearing officer.
Thank you, Chris.
The hearing officer is selected by OOD in the first place.
Mm-hmm.
So, is there any requirement that that's a level playing field, that both parties in the dispute have the same timeline for submit or exchanging documents?
It always is. Well, from experience, I've never had a hearing officer impose stricter restrictions on one party or the other. There's always parties are to exchange exhibits by such and such a date.
Thank you.
You haven't read this part. You read it. I'm a little concerned about this part. You can go on.
Okay. While the grievance is pending, the BE manager or designee shall contact the licensee to determine if the grievance may be resolved informally. Any informal meeting shall be scheduled within 30 calendar days of receipt of the grievance.
Now, let me ask you this. We got this. What level was this?
This is E.
E?
Yeah, it will become D, but it's gonna,
Okay,
so far we haven't made any changes to this.
because shouldn't this be before? You try to resolve it before the grievance?
So things changed in the last rule package. It used to be that we would do an informal, and then the operator would determine, yes, I want to pursue the 119 and I request a 119, or no, I withdraw my grievance. But it's my understanding to follow the 119 rules out of the gate. It has to be scheduled for a 119 no matter what. We weren't following the 119 rules. So people are informed, but then you have the informal, and people can still withdraw their grievance. The hearing just goes away. But that's why, and there was a change last time. And so now they have to, by 119 rules, is my understanding, schedule the hearing. Where in the prior packages, the onus was on the operator to request a hearing after the informal.
Okay. So now it's just automatic.
It's automatic.
That's Madam Chair.
Yes.
Brian.
Yes.
That technically under 119, that's not under 119. That's under our rules and under the Code of Federal Regulations.
Okay.
Scheduling of the hearing. 119 has different.
Sorry.
They have a different process that I won't bore everybody with. But
No, you're fine.
under this, it's under Code of Federal Regulations and our rules that require. It's a different scheduling of hearing, and it's a rigid process. But that's why it's like that.
Madam Chair,
Yeah.
I'm not a lawyer, but I stayed at a Holiday Inn last night, and that's why the lawyer's here.
Yes, I understand. So this is after the informal,
Mhm.
but before the 119.
Well, this is the informal. We're talking about the informal right now.
Okay,
But it is, you file a grievance,
yeah,
they schedule a hearing,
Mhm.
right from the start.
yes.
But, that the hearing probably won't take place for, a few months or something.
Mhm.
So in the meantime, within 30 days, you get your informal.
Informal.
And if you like what happens there, you can withdraw. And no hearing, they'll just cancel the hearing and everything goes away. If you don't like it, then the hearing's already on the books. This actually is a good thing because it used to be, 30 days out, you'd have the informal, and then you got 30 days to respond to that. And then if you didn't withdraw, then they would turn around. They had another, Lord knows how many days to file for a hearing. And sometimes the hearings didn't take place for a year or something after the initial response. Actually, since we've done this, the hearings are on the books pretty quick, considering.
And I'm going to suggest another phrase for 30, Madam Chair, if I may.
Yes.
While the grievance is pending, is what it says right now in E. Would it not be helpful to say, while fair hearing on the grievance is pending? Because that's essentially what we're talking about. We're waiting for the actual fair hearing, but in the meantime, we're going to have this informal meeting. So I would just suggest that E read, while fair hearing on the grievance is pending, then continue from there. Brian, do you have any problem with that?
The only issue I have with that is if for some reason it muddies the waters with time frame. The 30-day deadline is from the date the grievance is filed, unless agreed otherwise by the parties. But the 30-day deadline to do the informal. If you say while the fair hearing for the grievance is pending,
Right.
that could mean by literal reading of what you're saying, that would mean once the fair hearing has been convened and while it is actually going on, you can break out of the fair hearing and do an informal meeting. It would kind of muddy the waters. This specifically says grievance filed, you have 30 days to do it, and it's while the grievance is pending. The grievance starts pending when the 30 days is filed. The fair hearing starts pending when the hearing officer calls it to order when everybody's convened for the fair hearing. So it would just be, I think it would confuse things.
And Madam Chair, with that kind of suggestion, and I'm trying to think of this operator that doesn't do legalese, doesn't participate in these discussions, is not nearly so familiar with the process, and has a concern that they are considering filing a grievance about. When they read this rule, is that timeline clear to them? And so, in terms of is the process clearly comprehensible to somebody? And I'm looking, for example, at Lindsay right now, twisting her mouth saying,
Not with me.
"Yeah, well, but I'm thinking, is it's clear as mud?" Because we need it to be more clear than mud to the potential grievant. We need it to be very clear to the potential grievant without having to hire counsel to initiate a grievance.
I think it's written, Madam Chair. I think it's fine. I think adding stuff kind of does muddy the water. And again, a new person should be reaching out to you guys as OVRC and asking questions if they have questions. They shouldn't, go rogue. And again, we go over the rules too, particularly this rule for sure at training. And I think that's more of a training issue. I would just sometimes, just like with B that we added last time that we thought was helpful, and it confuses it. I think less is more.
Madam Chair,
Yes.
with all due respect, I don't ever remember a training on how to file a grievance.
Yeah,
Maybe I just blocked it out, but I don't think it ever happened.
The rules. It's part of the rules.
All right.
Go ahead and
Okay. The BE manager or designee shall provide a written summary of any informal meeting to the licensee with any proposed informal resolution. The request shall proceed to a fair hearing unless the grievance is withdrawn. And then we go on. The impartial hearing officer shall submit to BE a report and recommendation within 30 calendar days after the fair hearing is concluded. BE shall serve the report and recommendation on the licensee or licensee's attorney in accordance with section 119.9 of the revised code. The report and recommendation shall be based on the Randolph-Shepard Act and regulations as applicable, Ohio law and administrative code, and OOD policies and procedures. The licensee may file written objections to the impartial hearing officer report and recommendation with the director of BSVI. Written objections must be received by the director of BSVI within 10 calendar days of the licensee receiving the report and recommendation in accordance with section 119.09 of the revised code. The licensee may request the report and recommendation be served by other appropriate means after service is perfected. Huh? What's that mean?
Accomplished.
Brian, what's that mean?
The city may request that the report and recommendation be served by other appropriate means after service is perfected.
Yeah.
So service is perfected. It's a legal term of art. So service is perfected can mean different things depending on how you serve it, but it's effectively when service is. It's not necessarily complete in the sense that you received it, but under certain things, service is perfected when it's, with certified mail, it's when it's received by certified mail. If certified mail isn't received, and then it has to be sent by regular mail with certificate of mailing, it's when the certificate of mailing is requested or by the post office. So it's when it's put in the mail. So it means a different thing.
So it's referring to documents? So
Yeah,
It's services perfected of the adjudication order.
the report
Or the
recommendation.
Yeah.
Yeah, it's a report recommendation. So y'all mail it to me, but I say I don't want it mailed. I want you to hand deliver it to me or something. That would be other appropriate means or vice versa, I guess.
I might say that's not
Delivery?
appropriate.
But
Or
yes,
email it or skywrite. I don't know what other appropriate means are. I was like, what is that?
I thought you were requesting what services perfected.
Well, that too. The whole sentence is.
Yeah, I want to know what that meant as well.
Yeah, the whole sentence is stupid. Okay, I get it though. The director of BSVI shall issue an adjudication order approving, modifying, or disapproving the report recommendation after considering all objections of the licensee in accordance with section 119.09 of the revised code. Licensees may challenge the director of BSVI adjudication order by filing a complaint with the Secretary of Education pursuant to 20 U.S.C. 107 DEA of the effect on the effective date of this rule. A 3-member ad hoc arbitration panel will arbitrate the dispute. OOD shall have the fair hearing recorded in a manner that may be transcribed. Any party may request the transcript of the hearing at their own expense. And then at the very end, time limits created by this rule may be extended by mutual agreement of the parties. And then very nicely, the people that brailled this actually put the end at the bottom. I felt that was so funny the first time I saw that.
Like you read a little bit.
Yeah, it actually says the end. And they all lived happily ever.
So we made some changes to this.
Yeah, a couple fairly minor changes. I wouldn't call any of them substantive changes to that.
I have a question. Regarding the OOD hearing officer, it says that person is contracted by the agency. That to me implies somebody that's not an employee of the agency, but it seems to me that historically they've been agency employees. Is that not?
Never.
Never? Okay. Okay, then that's just my
Yeah,
misunderstanding.
we
Or
contract,
employees?
no,
Houses of them?
no. We contract out hearing officers, both for VR appeals and that, and it's my understanding that they're just on a rotating basis.
Well, I won't say that they're objective or anything, or whatever.
Impartial?
Impartial, that word. I'm like, well, you might as well just say hearing officer.
Okay, but that helps me to get some clarity because fortunately I've not gone through that process. Okay, as argumentative as I am, I've filed grievances, but they've never got to a hearing.
Well, Madam Chair,
Yes, Dave.
yeah, I kind of the hearing officer that is contracted by one side of any dispute can hardly be considered fair.
That's one night. I don't even think that's BE. I don't think there's a thing we can do about it. That's all be 119 how they do it.
The state agency is probably presumed, I'm sure, I'm looking to Brian as I'm seeking clarity on this. So the state agency is presumed to have the resources to contract that person versus the grievant is to be at a disadvantage financially versus the resources of the state.
Madam Chair,
Yes.
that is correct. The state, and this is with every state agency for the most part that I'm aware of. They are hearing officers are contracted by state agents. They're, it's put out for bid like any other state contract. There's requirements obviously for a hearing officer, and then, but yeah, they're always paid by the state. And I don't know that it said that anywhere explicitly that it's because of the balance of resources, but certainly that's the reason. Yeah.
Obviously, in our program.
Well, Madam Chair, it would be
Madam
a
Chair.
financial for a lot of folks, and not necessarily only a VE, but if you think of VR and, people who's unemployed and stuff,
Yeah.
actually it would be a denial of, if it was required that the grievant party had to chip in some ways that could be considered
De facto.
Yes, they just don't have the resources to do so. It's actually finding a way to deny them
Their due
their due process. So this is not by any means a perfect system because we do know the problems with it. But
Dave? Was that you, Dave?
Well, that's okay. I'll skip this one. I was going to say something, but it's not going to be beneficial, so it's okay.
all right,
All right, are we good? Anybody need a break, or we want to just move right to 5?
I think it's 5 minutes to stand up stretch.
Okay. You want to take 5 minutes?
fine, take fine. Oh, what? I've seen you more last week than I've ever seen you. How's it going? How's that new hospital?
Good.
Good. Me and one are neighbors over our storage rooms. We're neighbors, but we never see each other.
Lutz, I am avail myself of your vending on my way on my body break, and grateful for that energy shot at 425. Thank you very much.
All right.
I can tell you I use it frequently.
All right. I like that.
You have 2 rooms on this floor?
Yes.
Okay, because I thought that you had a combi in the other one.
Yes.
Yeah, the one.
That's fairly new. The combi's maybe been here a year or so now. I used to just have it in one room, but actually when they brought everyone back and have started and 400 closed and they brought the east side people here and stuff, the 2 machines weren't
Then a win-win.
doing it. They weren't. It wasn't effective. Because I come here once a week to service. And
So you
actually, for a little while, I was coming twice a week.
could break up your service trips.
Yes.
Did you have a strong day yesterday on 70?
Yesterday, no. The day before, yes.
I,
Yesterday was average. It was maybe a little above average, going up.
we were strong on both yesterday compared to average.
Yeah.
And
I did about 350 yesterday. So.
I did. Rebel did 538.
Wow.
And Miami did 638.
Oh, wow. That's real good. Now, the Wednesday, the day before, did real well.
I think you got people coming back from their holiday breaks. The people had the Good Friday start of their break.
Yeah.
And so I think you've got some returning folks now.
I'm hoping to have a good weekend this weekend, that's for sure.
You both talking about rest stops?
Yeah.
Yeah. We both have temp contracts on rest stops, and in my case, mine's on 75.
I'm gonna get there. You gonna be there?
Toledo and Dayton. It's kind of a weird situation. You don't really know how valid these numbers are when Annette's place is shut down to the north. Right. Her rest area is being demolished and remodeled or rebuilt. And then the same with Derek to my south.
Sure you wanna go.
So I'm the only Ohio operator on 75 right now. So the numbers that I'm generating really valid numbers.
Well, until they get to Hancock County at least. And there's a couple north of you, but it's still a little way.
Going southbound?
No, north of you.
But I'm saying.
But yeah, you're the last one going south
Yeah.
in
I'm the
Ohio
only
right
one.
now.
I'm thinking I'm the only one south of Ohio.
Well, no, we have Hancock County to the north
Hancock
of
has a southbound.
Yes, and so does Wood. So there's two other ones that's open right now.
Okay. Well, there's more traffic than I realized.
Yeah. But Auglai's and Butler are both closed, that is for sure.
How far is that Buc-ee's from your facility?
Buc-ee's is, it's on 7. Buc-ee's is on 70,
right.
mile marker 41.
Okay.
And drive time, it's about a half an hour.
Okay.
35 minutes is probably fair.
Okay.
Because I think you turn up onto 75, I think it's like mile marker 32 or something close to that. So you've got about 9 miles over there and then about between 20 and 25 minutes north up to Pickwood exit where you turn around.
So it's not on 70 or?
It is on
Buc-ee's
70.
is on 70.
It's on 70 at
You are.
235.
Yeah, and I think the
And how
disparity.
far is it from Butler, from Frank and Derek's?
It'd be a little bit further.
Yeah, it'd be a lot.
It's quite a bit
Yeah.
because they're way down. They're almost to Cincinnati.
Yeah, you've got to pass through.
So you're the closest, Chris, and it's still 30.
Well, no,
Madison County is probably.
and Madison is the one that's most likely to be impacted.
Yeah, the one that
Because-
me and Jeff run, and most especially mine.
Those two in Madison County are in.
Okay.
That because Jeff's at mile marker 71.
Yeah.
But it's 30 miles exactly from Jeff's facility,
Yep.
Okay.
and
And mine's coming away from Bucky, so I
Right.
think mine. If there's an impact, it would be on mine.
But
Because
so
it's
far-
after people
So
are
far,
that
you
close.
haven't.
No, I
but
haven't.
they've
noticed
only
that.
opened Monday.
Right.
Yeah, I was gonna say in 3 days.
I don't know.
Actually, we're having a better week this week than last. So
Mm.
so far, we're
I mean,
it's not showing.
I don't even know if everybody knows they're open yet, because I thought they were, I heard something that they supposed to open in June or something.
No.
No,
Okay.
they opened Monday.
Okay, let's get started. We on Rule 5?
Yeah, if we have to. All right, Rule 5, equipment, supplies, and initial inventory. All equipment as defined in 3304-121-1 is owned by BE and shall remain the property of BE at all times, including after determination of a BGA, BOA, or TBOA. Equipment shall only be moved or transported by BE program personnel or a third party hired by the BE program, but may be moved by an operator if the operator has received written permission from their BE consultant. The BE program shall be responsible for maintenance that is required to keep equipment operational. Cleaning and general upkeep of equipment shall be the responsibility of the operator as specified in the BGA for each facility. In the BGA?
What's, I do want to go back and revisit the part about the equipment being moved. I thought that EE doesn't, if you're moving your storage or if you're moving something like, having to go from what, I thought the Bureau, would not pay for that to have it. I thought
That's not true.
that's what I was told when I
Product or?
No, we're talking about equipment. We're talking about your racks. Racks are considered equipment.
They're not considered equipment according to RSA because they're under $1,000.
Okay.
They're not considered equipment, but we've been paying for some of that stuff out of unassigned income, that and locks and things like that. And
Yeah,
that's,
'cause a while back.
but that's not considered equipment anymore because they're under $1,000.
If it was.
Right. They're
Yeah.
But they
considered
could move those. There's nothing that says they can't move them.
Yeah, just a while back, I was told that they didn't, when I had to move my storage, I was told that we had to do it. I actually had to rent it before I got my truck. I had to rent a U-Haul.
I think it's inconsistent.
Okay.
And I think that that's a conversation that, again, the OVRC needs to discuss. Again, it costs a lot, it costs money to have Schaefer, travel to move racks and stuff like that. And
I'll see operator
It's
money.
relatively low value stuff. I mean, you can buy a 4-foot, 18-inch deep shelf at Sam's Club for $125. That, you're moving something that's going to cost you more money to move it than you could buy a new one for.
No, depends on what you're talking about. That's the difference.
It depends. I mean, you want a wider shelf loader or something.
No, what we wasn't talking about. We was talking about moving, like if you're going from one storage area, like if you got a new, you rent a new storage space and you need to move your equipment, your racks and all that kind of stuff to that new location. That's what I was.
Or refrigeration is equipment.
Yeah, refrigeration is equipment. So, but I was saying like the racks and all that kind of stuff. I said I had to rent something in order to get that.
and then you expensed it off, right? Again, RSA looking at it, Madam Chair, would say that that's a responsibility of the operator. It's under $1,000. It's considered a supply. It's an ongoing expense. But as a group, we can talk about using untied monies if that, and to do it consistently and hire Schaefer to move that. But I'm telling you, with the Coke contract going away and with insurance, that's going to be a larger conversation on how much monies are left in those buckets.
Madam Chair, that still has nothing to do with moving it. That has to do with purchasing it. Moving it is just,
So they were paying for that out of the shit.
I mean, I don't know why you couldn't move it.
Well, what bucket would we pay? It wouldn't be maintenance and repair. What bucket would we use to move people's storage racks from one facility to another that is allowable to
Well,
use?
if it's a new facility.
If it's a new facility, we
Because I know you are doing mine.
if it's a new facility, but an existing facility, there are
Remodeled.
right. That's where it gets tricky on the funding
Well,
and the allowable cost by RSA.
Argument for another time, but
This-
equipment you definitely would move.
Right. This is talking more about machines, that people can't just willy-nilly go and move machines without, we should pay for the movement. I don't want people to get hurt. When I read this, it's really about heavy machine equipment and
Well, we should have that. That's where that policy procedure, we should probably should have that
I agree.
more clearer in this because, that's just not the way it's being conveyed on the street.
And Madam Chair,
Yes.
and there are times to where someone is moving from a storage to another storage, and there's BE owned equipment
Mhm.
plus carts and stuff like that.
Yeah.
We have list that in the move ticket that this BE machine is being moved from this address to this address plus, a number of racks and
Yeah.
carts and stuff like that. we just run into situations to where there's no BE tag associated with a card or something like that.
And I do duly noted as far as where Christie said, it's been inconsistent. So I do.
It has. This other one, there's a B, it says the equipment of, the BE program shall be responsible for maintenance that is required to keep equipment operational. Okay, there's nothing wrong with that.
Well, Rule 5.
Cleaning and general upkeep of equipment shall be the responsibility of the operator as specified in the BGA for each facility. Isn't it just upkeep? The general cleanliness and upkeep, yes, is the responsibility of the operator. What is this as specified in the BGA for each facility?
I believe each BGA has, some meetings have specific requirements, like where trash and all of that, but the actual equipment, I don't know.
Yeah, so if my BGA doesn't say I have to keep my equipment clean, then
Right.
it's not my responsibility.
Right, so take
Yeah.
out cleaning and general upkeep of equipment shall be the responsibility
Of the operator.
period.
Period, yeah. Because if the BGA don't say it, then someone could argue, well, my BGA don't say that, so. All equipment shall be identified as BE property and inventoried according to OOD policies and procedures. Notwithstanding the above, all vending and other specified equipment shall be affixed with an asset tag identifying that the machine is owned by the BE program. BE shall provide each suitable vending facility or site. All right. BE shall provide each suitable vending facility or site with an initial inventory taking into account the items typically sold in the facility or site and any applicable provisions in the Bureau Grantor Agreement regarding items that are appropriate for the facility or site. Once the suitable vending facility or site has been established, BE may provide additional equipment in its discretion after evaluating the business need. All right, Lee. How we all want to tackle this?
Oh, Madam Chair.
We start with Dave first.
Dave, go ahead.
I just wanted to go back to D that Annette read. All equipment shall be identified with as BE property and inventoried according to OOD policies and procedures. Okay, I mean, that's fine, but does it really need to be in the rule? That's their policy and procedures. Notwithstanding this, all vending and other specified equipment shall be affixed with an asset tag identifying that machine is owned by the BE program. Again, I don't have an issue with that, but why is it in the rules? This is their policy and procedures.
I think it's in the rules because, Madam Chair, that, everyone's aware of what is equipment, what is tagged, everyone's aware of that, and they need to be aware of that. Those tags too, they're helpful for you guys on, calling when we do service calls, it's very defined. We've got BE equipment that are at people's homes that, coin counters, sorters,
Refrigeration unit.
yep, refrigeration units, so. And again, I think that these rules too, they're for the program. It's not just your rules, it's our rules. And there's responsibilities on both sides, but I think it's important that that stays in here. I think the big thing is what Annette's getting at now, that we need to figure out.
Yeah, where do we start?
Well, Madam Chair, before we get to that, for letter A, it talks about all equipment as defined in paragraph R shall remain a property of BE at all times, including after determination of a BGA, BOA, or TBOA. Should we put permit in there or no? Is it not like a big deal?
Permit, is it?
Yes.
Permit is a BG.
Brian, do you see that the same way? Because we refer to federal properties as permits.
Then you're better than me. So where are you talking about? Oh, for letter A.
5.
And you want to change it? What do you want to add? I'm just
Add permit, like, does it really matter if we add permit in there?
in addition to BGA, BOA, or DA? I don't see why not. I don't see why.
Termination of a permit BGA. Okay.
I don't think it's a big deal either way.
Okay.
All right, so now we're at the crux of it. This first sentence here about BE shall provide each suitable vending facility or site. Well, the first thing I would say is site. Shouldn't it?
What letter are you at? Yeah,
This is going to be E. With an initial inventory, taking into account the items typically sold in the facility or site and any applicable provision in the Bureau grantor agreement regarding items that are appropriate for the facility or site. Once the suitable vending facility or site has been established, BE may provide additional equipment in its discretion after evaluating the business needs. I don't have no clue why that sentence is there under inventory, but when we're talking about inventory, but
Oh, Madam Chair, my question about that would have been what kind of process or procedure is going to be used to evaluate the business need?
well, I would say, I keep seeing this word policy and procedures, but we don't have a handbook or anything to make
that's
sure
true. We don't even.
consistent. We have this word in here, but we don't have, I think we need to have policy and procedures in order to make sure we are being consistent and, and then that's the one thing that I'm,
Here,
Madam Chair,
yes.
one of two things needs to happen. We need to be very specific in the rule, or we need to be more broad in the rule, like kind of it is now, and have a separate policy that's more pliable to changing based off needs. That would also have to be approved by RSA, but to determine like what is considered initial inventory. And that the reason sites in there is because we do provide
I know you
additional
do.
inventory to sites. I know
you
that
do now.
you don't necessarily agree with. I think that, with an initial site, if you're talking 2 machines, do we give initial inventory for 2 machines? But what if the site is huge and has 20 machines? Can a person afford to provide their own initial inventory for that? That's the question.
Madam Chair,
Yes.
Well, I think
One second, Dave, and then I'll be with you. Oracle's first.
I do think that we should remove site. So if we provide each suitable vending facility with an initial inventory, it's a facility. It starts off as a facility for us. Like if somebody already has an existing facility and they go after a site, they're going after a facility. It initially started off as a facility under its own TBOA. But I do think this needs to be clear because there are operators who provide their own inventory, and then there's some who wants inventory, and then there's some who provides their own inventory, and then the facility ends up not being suitable, and they want the program to take care of the inventory.
Dave, okay, are we ready?
I'm fine.
You're fine. Yeah, I'm sorry.
Oh, you're fine.
well, I respectfully disagree. I respectfully disagree with that. I think sites should stay in there. I think Annette's point was the last part of E, where it says BE may provide additional equipment in its discretion after evaluating the business need. I think that could safely be removed.
Well,
Hopefully they would provide the additional equipment without something vague like may being in here.
Madam Chair,
yeah, so
Dave, why do you want site to stay in here? I just want to be able to follow.
So in your example, one or two machines that's going to constitute a facility?
Madam Chair,
Yes,
so when we go out there and we do a site assessment, we are creating a facility in our system. We don't even call it a site. Now, after 6 months, then we may put that out as a site attachment opportunity. Maybe I'm going too deep into it, but
I believe
But Madam Chair, respectfully, wouldn't, if,
Go ahead, Dan.
if it's a site attachment, wouldn't that be a site?
So, Madam Chair, I think that the clarity here is, Orville's thinking when we first establish it, if we have a TBOA, someone's temporarily running two machines, in BE Web, it is a facility when we're temporarily running it, even two machines. Then we put it out as a site attachment, and someone puts in a bid for it. Again, ideally, that initial inventory, which we pay for with a specific pot of money, not set aside, that should go with the new person who gets it. But what if someone underserved it and blah, blah, blah? Are we responsible as the agency to supplement that now site with additional inventory? And is it 2 machines? Is it 20 machines? That's the question. When I think what Orville's getting at, when it's first established, it is a facility.
Yeah.
And so it would fall under this. But then when it morphs into just a site attachment, and if there isn't enough inventory left from the temporary operator, what happens then? And if site is out of it, then we're not responsible for providing. But if it's in there, then we are.
Oh, well,
Madam Chair,
go ahead, Chris.
I didn't mean to interrupt you. I want you to finish.
No, you go ahead.
Just asking for the floor.
You go ahead.
That just, I've got a little experience with temps, and generally speaking, I try to provide the initial inventory whenever that I can cash flow that.
But not everyone can.
I understand that, and that generally, but just to offer, and Dave, pardon me, I think there's a little bit of the agency is trying to make sure they've got separate bookkeeping for this site attachment, separate from an operator's existing facility, because all too often somebody runs a site attachment and they're asked for sales information, and if it's been rolled into that person, if they've just been reporting it on their base facility, then we don't have good information on which to base the site attachment vacancy. That's really important. Operators deserve valid information on what kind of sales have been documented for a facility during the time that it was under a TBOA. And so that's why they create a separate facility number for it. And that sets us up for this transition then back to a site.
Madam Chair.
Yes.
To your point, I think policy and procedure would be helpful on this because, again, you also have situations where I think we have to, as a program, you guys have to come up with what are the requirements of a temp? Because I know we have some operators that, prefer cans. And so then the permanent person comes in, they don't want cans. No. They're like, take your cans with you and now supply me with bottles. So it's stuff like that with temps, we've got to look at it more of a program-wide, not a specific person temping, what makes sense for the program to maximize the profits that can easily transfer to and be incorporated into existing facilities when it's put out as a site.
Well, I would say this though, when you're doing if it's under a TBOA, you're taking on these temps. I'm trying to see. Taking the word site out of it, I don't have a problem with that because I think if you're taking on a site attachment, you should be providing an inventory for that site attachment. But I can't say that because I know there are some situations someone took on a temp and all the machines were empty.
Mm-hmm.
And they did not have the means because they were new to the program because we allow, new people to do site attachments or temping or whatever. They didn't have the means to pay for the inventory.
Well, Madam Chair,
Yeah.
they're two different things. a site attachment, you're talking about an established operator with a facility already.
Mhm.
So I don't know that we should be, sometimes people get tons and tons of sites and their initial inventory goes up and up and up and up.
Mhm.
Because we just keep adding and adding on. If you're going to take on a site, now, Christie's argument of 20 machines, boy, I cringe at the thought of a site attachment that's 20 machines, that's not a facility. If we're putting 20 machines into something, it should be producing a job for somebody. Not doing, $2,000 a month in sales or something like that. I mean,
Right.
that's absurd. But
Where's the line? Where's the line?
well, the line is if you can't provide the inventory for the site attachment, maybe you don't need it. That I cringe at that notion of it being so many machines that somebody couldn't afford to put them in there, but yet it's still a site attachment.
I agree.
Yeah.
I can help you with that. Where's the line? $1 per machine, and it depends on whether it's a snack machine versus a drop vendor versus a bev bag. But it's absolutely very clear cut what are kind of valid sales numbers for machines.
And Madam Chair,
Yes.
to Chris's point, other states have, it's a 2-week supply, it's a 3-week supply, it's per machine, there's formulas, it's consistent throughout the state. And I think we need to look at those things.
We do.
The other thing that again, we've been discussing this for 2 years. We've brought in Kentucky, we've brought in Indiana. The other piece of this too, and again, this is where I miss Amy, with RSA and their rules, which does hurt us, they're changing, and interpretation hurts us sometimes. It was so much easier 10 years ago, but there's also something that when a facility changes hand, that 6-month clock starts over again.
Mm-hmm.
So again, can we pay for even additional machines? And maybe this is in a procedure where if it's more than 6 machines, it's discussed, with the local committee on potential adding additional inventory to it. But I hear you, and I commend both you and Annette on that, because we've also had operators that have taken on sites over the years, I feel like the program's an ATM.
Yes.
Yeah, I think taking the word site, I out of it. I kind of agree that might.
Madam Chair, here's the thing.
Yes.
We can argue about this all over the place, taking site out of it, but if we're going to change how we do inventory, if we're going to keep inventory the way we're doing it, then these are appropriate conversations.
Okay.
If we're going to change everything, which is the proposal that at least had been on the table, then I think we just need to scrap this and figure out where we're going to go.
Okay.
Yeah.
Because right now, just changing words here and there, and then at the end saying, "Well, we're not going to do all this anyway," doesn't seem to make a lot of sense.
Right. Go ahead, Chris.
I'm seeking clarity from Christy and perhaps Brian on this question of where the challenges come in what you're describing as some changes made by RSA that impact use of funds. Because when I'm looking at Section 103B, Paragraph 1 of the Rehabilitation Act, it says that it permits VR agencies to use VR funds to purchase initial stocks and supplies for vending facilities.
Yes.
But you're saying it doesn't necessarily permit supplemental for vending facilities, or are you saying that? I don't know that I don't know that the CFR differentiates between facilities and sites.
So
They're all vending facilities, I think, from the standpoint of the CFR.
So, Chris, all this has come about. There was a TAC a couple of years ago.
Okay, right.
And how we've been doing inventory since as long as I've been here, and probably longer, is that everyone gets an initial inventory when they would get a facility, and they don't have to pay that back until they leave that facility. Well, what RSA is saying is, no, you either need to have them pay for it back within the period of performance, within the 2 years, they have to pay back. And we've got people that have initial inventories of like $30,000 that they would have to pay that back, and then they would own it. And then what happens They deal with the incoming inventory with the incoming operator when they transition. That's one issue. The other piece of it is too, and we discussed this, that when an operator comes in as a new operator, VR pays for the inventory, the initial inventory for that, and it's theirs. It doesn't come out of BE pots of money at all, the DUI money. It can never come out of set aside, which it did for years, and we were told that's wrong. What we're fearful is that RSA comes in and audits. They will say we are doing it wrong by having these lifelong loans, interest-free loans, which was not the intention of RSA.
Well, I think it was originally. And the initial legislation, it absolutely was.
But they've changed it.
Yeah, so they changed the
They've
policy.
changed it.
No,
They've changed their
it
interpretation.
absolutely was until you're saying 2 years ago.
Well,
Pretty much. Their interpretation
Their
of it
interpretation
was
changed.
what did change. They do no longer allow that. And then the other thing, Madam Chair, I should have.
Yes.
The other thing that we should needs to be done is there is some freakish thing in this that when an operator pays back, the Bureau has to go back and somehow put that on the report of when they paid it back. It's very convoluted.
So what they're saying, Madam Chair, is if someone pays us back after a 2-year period of performance, we relinquish that funds and have to give it back to the feds. That's what they're saying. We have to give it back to the feds. It loses some identity. We can't keep that even in a bucket to help regenerate new facilities coming up.
That's moving forward.
That's what they're saying. The other piece of this is when we are creating a new facility, not an operator coming through training, a new facility, the Bureau is responsible, and we're using DUI monies for this right now, to set it up initially. We set up the new facility with inventory. But then that becomes, it's gifted to the operator that's there, that gets that. And then it becomes them. So again, would not be owed back to the Bureau. If VR buys it, not owed back to VR when you leave. The question and problem and the crux of all of this is that then you guys have to deal with each other during transitions. And it's the matter of disagreements, arguments, or does the person have the choice to bring it with them? You either take it with you or you sell it to the incoming. Taking it with you, all the expense. Can you imagine having to do that with a large university? I mean, that would just be very...
The can versus bottle question and all that.
Oh,
You just said exactly what I was
and so there is a feeling that there will either be a disadvantage of being the outgoing or the incoming, and what are the requirements about that? That's why we've been trying to have this conversation for a couple of years. And there are other states that do this. And the Bureau's responsibility for it would be that we would go in, we would be there at the transition, help the counts and help any disagreements, but we would not own that inventory. We wouldn't take responsibility, we wouldn't own it. Now, the other piece of this, which just left my mind, but it was pretty valid, maybe it'll come back to me.
So you're saying, just to speak for clarity, Madam Chair.
You're fine.
So you're saying option A is the agency buys it, it has to be paid back to the agency within 2 years, or you're vulnerable to the clawback from the feds.
Correct.
And B, the VR provides it, operator owns it, then transition is between outgoing and ingoing operator.
Well, go back to choice one. Operator pays it back to the initial inventory to the Bureau.
Right.
Then they own it. You still have that issue with the transition when you're transitioning because the operator owns the inventory.
So whether you went with option A or option B, operator would own the inventory by point of transition in most cases.
And one of the things that have been discussed, because again, to get into compliance with RSA, is that we've got inventory a lot on the books. We've eaten a lot of inventory, the Bureau has over the years, that we would forgive and set the clock over, forgive all on the books inventory for everyone. And, one of the things that was discussed was we should make whole the people that have done the right thing, not the right thing, but have chosen to pay off their inventory, that they would, they should be compensated. It's not fair that they paid it off and most people have a ongoing loan. But that we reset, but we need to have parameters and parameters of, how much initial inventory, like it should be consistent and it could be based off of location, like colleges and universities versus Pinelli's versus C stores and that there's some formula there and other states have that. And then how do the transitions work? And that's why this is so important to then be able to figure out Rule 7. And Madam Chair, I have a question for Annette.
Uh-huh.
And that, we had Indiana and Kentucky come,
Uh-huh.
and you said you liked Indiana, and I'm always still confused on what was the difference between the two that
I don't know.
you liked. Because I thought that they were.
I don't remember. I'll be honest with you. I don't.
But this does work in other states.
It does, but my fear is, and Madam Chair, and it's the same fear I've had all along. Say, okay, me and Chris, and Jeff did too, provided our own inventory, say for these Madison County things, and Miami County, the temps. And if we put a new rule in place that we own that, we have, and we do, we didn't, the Bureau didn't take any of that. When we leave there, right now, under our rule, the new operator will come in, they'll count what's in the vending machines. That'll be transferred over as part of the initial inventory to the new operator. We're made whole because everything that's counted that's there, since we have zero initial inventory, we're going to get paid for. Under this new rule, we wouldn't get paid for anything. I mean, everything we would leave there, either the operator would decide to buy it or we'd have to take it and pull it out of the machines. What my fear is that operators, if they're concerned that they're either going to have to transfer for a lot of product or not get reimbursed for product that's left there, they're going to run it down.
Yeah.
That's my fear. That's been
Take it with me.
Yeah.
Take it with me. I'm sorry. I mean,
Yeah, we're not just going to leave it there, but we're not going to leave a lot of stuff in them. I'm not going to fill the machines up maybe 3 days beforehand just to go and pull everything back out again. It's going to be for, and I probably would if I knew the operator coming in and this and that, but a lot of them wouldn't, and they'll have them empty, there won't be a Snicker bar to be seen. They'll take it on, let it all run down, and not have nothing.
Madam Chair.
Yes.
They do that now, though.
What'd you say?
They do that now. They're already running.
Yeah.
I mean, I know it's in the rules where they're supposed to keep it nice and it's supposed to be perfect for the next person, but that does not happen.
And Madam Chair, I've talked to other operators in other states at last, and I brought this up, and they're like, why would an operator do that hurting their own sales? If that's hurting their own sales.
Yeah.
Because they're worried about
They're
worried about getting screwed.
Well,
at the
you've
end.
got some people that would probably do that. I mean, they can even let it run down to half, just not have it maxed out or something. But most people, like they said, they're doing it now. I mean, I can see people just saying, okay, fill it yourself, figure it out.
100%.
Madam
But
Chair,
are we only talking about under temps?
All of it.
Regular.
Madam Chair,
Yeah.
okay, rest areas is one thing. You have 6 machines. It would be doable if the new guy came in and said, I don't want any of this. It's probably doable to load the truck up. I'd be cursing them about the whole time while I'm emptying the machines,
Right.
but it'd be doable.
But
OU would not be.
No, it would not be.
If someone came into OU after you and said, I don't want a scrap of this
Right.
stuff,
Right.
and all of a sudden you
That's
got
the
to
problem.
empty 100 and some machines and
Yes.
storage and all this and that, that's a problem.
So, but Madam Chair,
Yes.
this procedure would help, but
Yeah.
also, if someone comes into OU after you and says,
Mhm.
I don't want any of your product, okay, how are you going to procure your product then
Exactly.
to replace it? You're going to go to a bank and get a loan, you're going to open up a VR case to ask them to pay for it. If you're going from a smaller facility to a bigger facility, and you could do that, that will take time.
Mhm.
Like the work it would take for them to do that. The other piece of it is again, I think more with temps, less with regular things, and we do have transitions where, if you're running a site or a facility, you do have the ability to decide what you want to stock it with, but there should be certain things that, people have purchased that should not be on a brand new person or even on an existing one that was a business decision.
Yeah.
I can think of, and I'm just using these as examples. We had an operator and great, wonderful, and it was a great transition. He has chosen to put Amish goods in a vending machine, but he talked to the incoming, do you want this, do you not? If you don't, I'm going to take it. But we shouldn't force someone to make those decisions where if they go off the basic thing. And that's the other thing. When initial inventory is provided, whether that's by the Bureau for a brand new facility or VR, it should be a standard, what is normally sold.
Yes.
And if someone wants to then go in and experiment by trying different things,
Yes.
they shouldn't expect an incoming. And that's where
I think that's a no-brainer. That should be.
That should be likely.
Yeah.
But I also think that there's going to be more coordination prior to transitions that would be required. Conversations between outgoing and incoming. What are you planning on taking? Can you provide me what your last Vistar order was? Can we have a conversation? What are the dates? I think that those conversations can happen. Now, again, I know it's apprehensive. It's a huge change. But in these other states, too, it has worked. There hasn't been, because I've asked, have there been grievances? Have there been anything? The lady in Kentucky, she said that, I think there have been circumstances where they've said to the Bureau, this person tried to give me all this stuff that was, and we've had this too, where there's been operators, I can give examples, where a new person has come in and they dumped all of the 7-Up in their storage on this person, and then that became that person's initial inventory, and that was not right.
Well, I do know years ago, we were made to feel like you had to take what, it took me years to recognize I don't have to take that because
But then the Bureau eats it, and RSA is saying that that's not right either, that we don't give credit for the incoming, and we don't require the outgoing. We give credit for the outgoing, and we're eating that. And so, yes, that's the other argument. Well, Christy, you erasing everyone's debt when we have about, I don't know, the last I checked, $400,000 worth of initial inventory out there. But it's just transferred. It's on paper. It's never been brought back in where we have a bucket, where we can. And then again, we're in the same situation on transitions if people have to pay it back within a 2-year period.
Okay, so where are we? No, but I mean, as far as if you got a transition, okay, we're talking about an established operator, a new person comes in, I'm going to use OU as an example. Someone comes into OU, VR will pay so they just say, I don't want any of this stuff, and want to bring in all. We don't have anything to.
VR right now is not paying for anything. We've not established anything. We're on this old system, and until we figure that out, we need to go back to VR. But there needs to be parameters on VR too.
What I was saying, moving forward.
I can't see VR paying $45,000.
No.
Yeah, but no, I'm just saying moving forward because universities would probably be what the largest.
Correct.
Our biggest issue.
Correct.
When we
Madam Chair.
Yeah.
This is Juan. May I say
yes,
something?
Juan, of course.
When I took 844, I had 42, 43 machines. I was left with $1,400 in inventory.
How much?
$1,400.
Okay.
So I had max credit card takeout loans in the quality of $9,000 to $10,000 to fill those machines and the coin mixes and everything.
But Madam Chair, in all fairness, when you wanted to do that, we said, well.
No, yes, they did offer, but I always like doing my own thing. They did offer, but I furnished everything. And my reason for saying this, I think there needs to be some set, as to what's left, how much is left. I'm also put in a position where now I'm temping the new hospital. In my own in 844, I don't have any. So now in the new hospital, I've got pop. I'm put in a position where do I have to rely on the new operator to take everything? Because if not, I have to deplete those pop machines so I'm not stuck with pop that I can't sell.
And Madam Chair,
Yes. Or-
Juan, and I'm not sure what people would think about that. When it comes to that, and you know, somebody goes in, the OVRC, it's like this is a side attachment opportunity, it goes to somebody else. When we count you out, knowing that you cannot take your pop to your permanent facility, we would give you credit.
Yeah.
I just don't want to screw anybody. But
We,
We can.
but no, I'm talking about like right now.
Right now,
what we have going on.
Yeah, under our current rules, yeah.
How do you deal with those situations?
But in
How do you deal with
future
those
sense,
situations?
we couldn't take it.
Well, that's going to be outgoing and income, and they will have to figure it out.
Correct. That's the crux, right
Well,
there.
now-
right, that's the point. Because I would stop buying and start selling everything out. Because what if they don't want it? Then I'm stuck with stuff that I can't get
Well,
rid
then
of.
that's where we have to come up with, like you said, a policy or procedure or whatever, because I know you can't force anybody to do that, but you can't also leave the facility empty.
Correct.
You can't, maybe we have to have something where any council gets them if they do that.
Madam Chair.
Yes.
And don't throw nothing at me just yet. I mean, why can't somebody, when they go into a facility, and I'm not talking about a whole storeroom full of product and
Like teddy bears.
everything and all this. You have stuff that normally is sold, like Juan's Pop. Why can't we tell the new operator that comes in there, you have to take what's there? I don't understand. I mean, if it's regular, I mean, I assume he's not selling, Joe's Cola or something like that. I'm sure he has Pepsi or.
Some people
Those
do.
products also.
Oh, that's right. Also.
I think the issue would be if somebody's selling cans and
Yeah,
you,
but
and
get
you
rid
think
of them.
bottles would be a
Get
better.
rid of them. Sell them.
Just sell through. Just sell through.
Yeah, Madam Chair.
Sell them
Yeah.
through. I mean, if there's 10 pallets full of it, that's one thing.
Yeah.
But if it's what's in the machine or a couple cases on the shelf or something with reasonable time, sell it through. Just get rid of it. And then you can switch to whatever you want. You might have the first week or so of your facility where you're not selling what you want.
Right.
But then
Eventually.
you'll be able to get your stuff in there.
Lindsay, then you are. Well, Lindsay.
I mean, this is just like an idea, but what if that situation, Juan, you would work with the incoming person and you could be like, okay, I can sell this down in however long it takes you. I go ahead and order what the next person wants. And then that way they would buy it off of you, whatever is left. And even if you have to extend out how long you're going to be pipping that location, even if it's for an extra month. I mean, that could kind of make it to where the next person would want to buy your stuff. I mean, obviously, not everyone wants to do that, though, either.
Madam Chair.
Yeah.
Madam Chair.
1 second, Orville wants to say something.
I was going to say, like, I agree with that. I think when it comes to a sellable product, you have to keep it. Now, if you have a vending machine that we have sundries in it, like in a snack machine that has snacks and they got deodorant or a charger or something like that, that shouldn't be forced on the incoming operator.
But Madam Chair, and I can send this to everyone. I have done research on other states, and they do vary. And there are some that are still doing it the way we're doing it. Mm-hmm. Nevada, incoming initial stock. The incoming stock acts as verification of working capital, the value of saleable product. It is conducted on site by the incoming outgoing operators in the presence of BE officers. If there are any personal items noted in the BEN site file, the outgoing operator shall remove those items prior to the start of inventory.
Like that.
Small wares, decorative displays, serving utensil, knives, similar items purchased with state funds must remain as state property. An agreement must be reached by the incoming and outgoing operators regarding the count of incoming initial stock and documented. Outgoing initial stock. The outgoing operator shall be responsible for having the following: inventory forms prepared on an Excel spreadsheet, copies of invoices on site to verify unit cost no more than 6 months old, So, I mean, I've got Nevada, Connecticut, Indiana, Illinois. Is the transfer product between vendors operators? Yes. Does the SLA have to be part of the transition or responsible for product that's not agreed upon? Transferring of product, yes. Indiana, startup product inventory purchased by the state as part of vocational rehabilitation plan is the property of the licensed manager. And then I've got Kentucky,
Kentucky had someone coming in doing they have a company that
Yeah.
and so does Indiana. They have
they have a company that does.
they do. And it goes really
I'm
fast.
sorry, Chris, you wanted to
That's
say,
all right. That's all right.
go ahead.
Since I think we all recognize that most people approaching the program early in their career do not have the financial resources to provide their own initial undertakings. That, the program has always been intended to be a turnkey opportunity for that person who has been unemployed. And I think we need to maintain our attachment to that initial legislative intent. And so that to me is central. I can certainly appreciate, and maybe VR provisions would help to achieve that legislative intent in this era where the TAC makes other alternatives unworkable. But my concern, and I can appreciate maybe what we're saying is that once the initial has been provided, and that operator who was unemployed, has some experience in the program, has had a chance to establish some cash flow, accumulate some resources, maybe build their credit, they're in a better position to then perhaps acquire their initial for their next facility. It's nothing more than like growing a business in any other arena. Maybe you started out owning a C-store before you owned a grocery, right? And so, what you could cash flow for your inventory increased over time as you had more business. Is that kind of where you're going, Christy, in terms of how we would provide for supporting the initial legislative intent, but then expecting the people are going to maintain some responsibility? My only problem is in this operator to operator transition. If I'm the outgoing operator, where am I going with my money? When am I going to get my money? If I'm going to give you $10,000 in inventory and you're an unproven operator to me, if I don't have a trust relationship with you, you got a credit app? You got a credit rating? You want to show me your score?
Yeah,
I can address two things from Chris.
okay.
So, Chris, what you said in Florida, and again, we can ask other states too to come to OVRC or come to these meetings to talk about it.
Yeah.
Florida, part of their selection process, you have to show that you have the capital in order to bid, that you've got that capital, that you've got the means to be able to pay for the inventory when you bid. That's one of it. The other piece that I wanted to tell you guys is that, again, there was a project with BEP states a couple of years ago where they looked at Ohio, West Virginia, and I think there was one other one, Utah or Colorado. And then NABM did suggestion rules. And some of them, so here is the suggested rules by NABM surrounding this. Again, you're not going to like it.
This is NABM?
This is NABM. The
I'm on that
operator
board. I'll take care of it.
The operator responsibilities. 1, pay the agency the full value of initial stock provided in accordance with a payment schedule developed by the agency with active participation with the committee of line vendors. Failure to make timely monthly payments will result in disciplinary action up to and including termination of license. SLA responsibilities. Furnish the operator with a complete inventory listing in an accessible format of all equipment, initial stocks, and cash provided. 2, initial stock. The vocational rehabilitation counselor shall provide initial stock and operating capital in sufficient amounts to ensure that the operator can successfully begin operations in their initial assignment. If the operator accepts another assignment, it will be that operator's responsibility to provide initial inventory at the amount provided by the VR counselor. They may either take the merchandise with them to their new assignment or sell it to the incoming operator and use the money to buy stock for the new assignment. If the new assignment requires more stock than originally provided by the VR counselor, the agency shall provide the additional amount in accordance with the policy and procedures manual. Under no circumstances shall an operator in good standing be denied an operator due to inability to pay for initial inventory. So that answers the whole thing where if someone tanks a facility and you go in there and there's not, and you don't have means, again, I think that two things could happen. Either that operator, the existing operator, could open up a VR case, or there's a provision that we have funds that for the first initial 6 months. And in talking, I think that clock starts over. I think that's the one loophole every time a new person gets into a new facility.
I don't not necessarily, I kind of actually like some of what you just read. I think, from my initial hearing of it, I don't see a problem with some of it.
Yes.
I think that the problem comes towards the end when you're providing the additional. I believe I'm trying to think of what part of it you read. I think when they're providing the additional, they're taking the inventory with them to their new facility, and if the new facility needed more inventory than what they had,
then we're responsible if
Okay.
someone taints the facility.
Mhm.
And so that's my worry. Is if someone taints a facility that should, to one's point too, like it should have, let's say, $8,000 worth of inventory, and a new person takes that on, not a new person, but an existing operator takes that on, and it has 4,000.
Yeah.
And they don't have the capital to make up that 4,000.
Right.
At some point, either they have to open up a case to get that, or we supply that. But then again, that becomes the property of that existing operator.
Yes.
Unless we do the payback thing.
Yeah.
But if we can do the 6 month thing, it becomes a gift to the incoming, but then they have to sell it to the next incoming. So that's the other piece of it is that you guys are getting this initial gift.
Mm-hmm.
And so,
But that's that would be through VR.
not necessarily. If it's a brand new facility, it would be through this pocket of money. But it would be a gift that you guys are selling that and then replenishing it. The problem becomes so then you're selling that. Like, let's say you got a gift, right?
Mhm.
And then 3 months later, you're selling part of that gift to a new person. The problem becomes if you've been in a facility for 20 years, you got the gift worth, the wholesale value worth $8,000, but now because of inflation and price of everything, it's worth $16,000. You want to at least get that $16,000 back and it not cost you, but you should be making money off of it twice, if that makes sense.
Yeah.
But, Madam Chair, people will. But what about the whole 2-year payback thing? Operator goes in, even if VR provides it, wherever the initial inventory comes in, if somebody, or you come in and the outgoing operator left it there, and we count it just like we do now, and you get 2 years to pay it back. Yes, you own it, but the operator coming in, there is some teeth in that. They have to pay that back. Where if it's just paying to the outgoing operator, there's no, as like Chris said, there's a lot of operators in this program I would trust, and we'd shake hands, and I know they'd be good. There is some I wouldn't take a check from, and I'm not going to say any names,
Right.
but there are some I wouldn't want any part of. You better show up with cash money if you want me to leave anything.
There could be a requirement of bringing a cashier's check. And some states have that too, that you have to bring a cashier's check.
Actually,
You haven't even determined the amount. Yeah, you don't
How
know.
can you bring a cashier's check?
That
You don't know
could
how
be
much it
determined
is.
prior to the transition.
Rough numbers.
Right, yeah, rough numbers, very
it
rough.
wouldn't be exact. It wouldn't be
Very
exact.
rough.
Well, I mean, you could make up a difference with cash.
I would think you would have to do the exchange. You would have to, before the final paperwork has to be done. I mean, that's probably why they got the companies coming in doing it. Because that guy said he could do the boom that day, come up with the number. That might be what you need to do.
But then there's safeguards too, I think, that we can look at. Could be part of the selection process, like Florida, you have to prove that you're the capital. And then the minute someone can't pay, like,
Then they don't get that, so they.
well, there should be consequences to that.
But I have real problems with the Florida method because it really defies the legislative intent.
Yeah, I agree with that.
It just spits in the face of the fact that we're taking somebody off of SSDI who ain't had two nickels to rub together all their adult life.
Yep.
And we're trying to give them a leg up.
But the RSA's interpretation with the TAC is that this program is to set people up. And I think the initial, if you look at the original CFR and the revised one in 76, they even talk about transferring equipment after so often, that the initial intent was to get people a turnkey operation once. That was the initial intent. And so we're not saying that we're not doing that. It's the promotion and the transitions and people promoting up. And we have said that if someone's going from like a small route, a basic route, and they want to expand into a cafeteria, into that there is a way, it's a job safe, they could open a VR case, they could be, that's a way to do
To
it.
get an additional
But
inventory.
the other piece too, Chris, that one could argue is that once you get your initial facility, the turnkey paid for, there's also, like it or not, there's beliefs there that then you could do what Juan does and go to your bank and get a loan or take out credit to promote up. That the intent of the law was to get someone a turnkey operation, but then that's their leg up, but not to help them for 25, 30 years.
Okay, so if we were to follow the, and I just don't know which one, and I get what you're saying, Chris, about the Florida thing, that really does fly in the face of getting a new person started. But the 2-year payback thing, so they're buying the initial, if VR buys it, they don't have to pay it back. But if you
Correct.
all buy it,
Correct.
they have to pay it back.
And if they don't, then we have to give that money back to RSA, which I don't necessarily agree with because it's not set aside, but what it is we use DUI money and then we match it. And that matchable dollars would have to be relinquished back to RSA.
It should be 80%, basically.
Yes, 77 point.
It's 77 now.
All right. Madam Chair, let's think this through. We get, brand new person, we're going to get VR to do it.
Yeah.
I think that's a given.
Yes.
There's no problem there.
It's the
Okay, then when we go and we have established person and we do a transition, and I bid into a place that Chris is running, and Chris leaves me some nice inventory there, and I think what we should look at is, and Chris says, hey, I'm not taking a check from that shady and that. So I owe him the money though. And the Bureau covers it, like they do now. They pay him for his inventory. Now I have the debt. The Bureau paid my bill for me. I get 2 years to pay the Bureau back. If I don't pay, we can definitely put safeguards in the rules that, if I don't pay, I'm in trouble. I could lose my facility. There's teeth there. The problem I worry about, if we don't do some kind of payback thing, and Chris, even though he thinks I look shady and all that, he feels he has to take the check from me, and it bounced. Chris has no recourse but to just go and the program won't. You guys might say you will. You won't. You won't get into a dispute between operators. I just don't see that happening. Chris would have to sue me in court, and I mean, it's not something he would be liking to do, I would imagine. He wants his money right now.
I think you more have a problem in that with that scenario you just came up with. If the person who now they owe the Bureau, they on that payment plan.
Yes.
They leave the facility before it's paid off.
Mm-hmm.
Yeah, that could get in nasty.
What happens then? If they leave that facility, they still own that debt. So if they try to get another facility before they pay that debt back, because you can't have the incoming person owing
Clear that.
their debt.
Correct. No, you can't.
I think that's where our problem will come in.
This may be ugly sounding, and I don't know if I like it. But I'm going to say it.
Pay it off.
You got to pay it off before you get
gotta
on
pay it off.
something.
Yeah, it's the same thing as, same thing we do about unpaid program obligations.
Yeah.
You got your debt has to be paid off before you
can
bid. You have to pay it off.
Pay it off before, yeah.
Even if something comes open today and I send a check for the whole amount, I might be on a payment plan and all of a sudden, my dream facility comes open. Well, then I'm just going to write a check for the whole balance so I can bid on it.
And I wouldn't say before you can bid, but if you are to before you can transition into
Yes,
that.
okay, even better.
That program debt, that debt has to be paid.
Even
before that
better.
final.
Man, that's splitting hairs.
Madam Chair.
You guys are having these payment plans just so you don't have to avoid working with each other.
In certain situations, in select situations.
Madam Chair, sometimes, because we have seen how disputes between operators, we've had to go to the mat when we had some disputes with folks in Cincinnati where operators one got paid and the other didn't, and that should have. The Bureau just said, that's their problem between operators, not our problem. And that's exactly what you will say then. If I bounce that check to Chris and he's out his money, you're not going to do a darn thing about it. You're going to say that was between the operators. The Bureau doesn't own the inventory. We have no part of it. Shame on Chris for taking a check from Shazonet. That's what you're going to say.
I think having that payment give the outgoing operators some kind. Everybody some sense of security. I will say that they're not only the incoming, the outgoing person.
So how do we handle this though with the existing process where people owe money, you're going to erase that? Now, do we do that and we start over and we have a new startup plan, and then when people move, then we're going like that? How does that transport? Because I've got people that do owe $30,000.
Be honest with you, I don't see how you could do anything but start over.
I don't either.
There's no way to get around that. You would have to eliminate and start from scratch. And this whole system is.
I hate it.
And I also think I've got to work with fiscal on this. The period performance, it's based off of the federal grant, and this is where we also get into trouble. Where if you are at the start of the federal grant, it's a 2-year thing in my understanding, and it's October. You have 24 months to pay that off. If it's the last 6 months of the performance period, you have 6 months to pay that off. It's not an automatic 24 months. It's not an automatic 2 years.
That's correct.
Yes, that's a problem
we need to
too.
Clarify
That's
that.
the problem.
Yes, it's not.
Is
It's
that
a period of performance.
And we're bound by that?
Yes.
So essentially, we can only transition facilities at the start of the period of performance.
Well, yeah.
In order to give people 2 years.
That may
Right.
be limit for when we can transition stuff.
Correct.
We may have to follow that because that's rough.
And again, if you guys want to
But
ask Gary Smith to come in and explain the tech and all of that.
I don't.
Will that only come in for people who needed that? Who needs that? I'm trying to think. Yeah, who needs the payment plan? Because if someone comes in,
I mean, it would incentivize people not to want the repayment plan. But then you've got people on the payment plan, but then you also have people that own theirs. And again, then you have, 2 different systems where one wants to deal with, Chris and Annette want to deal with each other, but Chris and Juan don't. So the Bureau then owns that and is the bank between Chris and Juan. And again, we're not going to eat the product that, give credit to one and not the other like we've been doing that probably isn't legal. So there's a lot.
the only other issue
here.
you have to use the Florida thing where people have to come in and again, that will disenfranchise a lot of people because people don't have that kind of money. Some people don't even have good credit to get that kind of.
But
yes,
how do you show that you have them? I mean, I can attest to the fact that I have the money, but I don't know that we want to be in the business of seeing people's accounts and,
Yeah.
you know, then
It means about how they document it.
Yeah, but Chris, you're arguing against your own point from 20 minutes ago. Initial person, you know, we need to give someone, but then once they're
I
established,
was trying to
they
get
should
clarity on
be
that.
able to grow and take their, you know, save money to be able to go to the next facility and blah, blah,
Yeah.
blah.
Well, you said this program is a turnkey. It's a turnkey where it's
Initial-
initial.
Not
But
20 years down the line.
right,
Here,
yes.
to be clear, I was trying to wrap my mind around how to find a middle ground here. And I would not say that I was arguing for that perspective, but I was trying to articulate that which I believe to be an achievable middle ground. And honestly, I'm certainly a product of my experience, and my experience has been that the agency has provided initial for new facilities.
Yeah.
But I'm sensitive to the situation of people who are economically disadvantaged, who are blind, which most of our program participants don't come in here with much to work with. I could not have demonstrated financial capacity at the time I started this without somebody basically loaning me the money. I would not have had it.
But everyone's saying, no one's saying, RSA and we are not saying that we're not going to help the new person come in and set them up. It's the existing, it's the ongoing and all of that. And what I've been trying to say is, and I've talked to other operators and other, you know, we need to talk to other OVRCs. And I've done the research where I wish, instead of reinventing the wheel, we can take the good from all these different states and try to come up with it. The truth of the matter is, this is going to be a wholesale change on how we've done it,
Yes.
at which no one wants change, no one, and it's confusing and the unknown. And yes, and so I think that, again, I will get out to everyone the research, the basic research, the tact, I think is important. But we have to figure this out. And this, you know, we've been kicking this can, and it's going to take a minute, but it's going to be a wholesale change.
Madam Chair?
I think we have no choice but to start from scratch, though.
Yeah.
And yes, Chris.
One of the things I'm really concerned about in terms of an inventory transition, or what amount of debt is attributed to an operator when they go into a facility, is that there not be an outsized amount of initial inventory in relationship to the potential net proceeds of the facility. And honestly, I think that's the problem with OU. Is you've got a large amount of initial inventory that is at least comparable to what 1 year's net proceeds would be.
Yes.
And so that's not a viable
Yes.
ratio,
Yes.
because the person doesn't then have repayment capacity.
Yes.
And so we've got to have some sort of
You do realize
attachment.
like the bid wasn't quite correct.
Yes,
about their-
but I can only work
It
with
was
what's on paper.
It was extreme.
Okay, I can only work with, I know she said $350 per machine.
I know, but that was kind of,
Madam Chair.
Okay, what did that number end up being?
no, we haven't done it. We're going to do it.
Oh, you have to send it. Okay.
Madam Chair, this is right. It's been inconsistent throughout the state.
Mhm.
Some people do it different. Some people, you know, I've had a recent transition too, where, you know, originally it was, well, they need 8,000. Well, the person before them needed 13. Well, now it's 12. Well, now it's 10. Well, now it's 9.
Okay.
There's no basis on fact and data and formula, and I feel like sometimes people just pull it out of the air.
Yeah.
And there needs to be some sort of consistency. The other thing that I'll tell you is other states, it is kind of all over the place, where some states it's 2 weeks of inventory.
Yeah, that's what.
Other states it's 3. I don't think anything's more than a month, but I have operators that truly believe that they should be able to fill their machines full and have a storeroom of initial stock. And so it's all over the place. And that's something that I think a policy and procedure
Yeah.
to define that, to define the expectation of what people should be,
What's
selling.
appropriate.
Right, like,
Yeah, it's gotta be based on-
if you want to sell, Mr. Pip that no one buys, that's fine, but you need to take it with you because no one's expecting an incoming to have 15 cases of Mr. Pip when they come in.
Oh,
Okay. Thank you.
I think that actually helps too with, if we set a limit,
Mhm.
that does help with if there is the Mr. Pitt here,
Yeah.
it's not gonna be that long. It's not gonna be that much. Like me and Chris, you sell it through, because there's a limit. You're not gonna have 10 cases of it sitting there because that's not appropriate for a 2-week,
Yeah.
turnover of product.
Yeah, but turnover ratio is what we're talking
Yes,
about.
Right.
that's exactly what we want to find.
Years ago, in Silver location, they had a lot of novelty items, like
Yeah.
teddy bears
Yes,
and that kind of stuff. I mean, you should not. Never should be.
correct. It's not a
They have a
normal,
load of that stuff.
that's not a normal thing. Anything that's not normally associated with that, Juan can only sell Coke in the one location. If someone showed up and there were 10 cases of Pepsi there, they probably need to be concerned.
Yeah.
Because it's not going to sell there. So,
It gets you in trouble with the bank.
yeah. So you got to watch that type of thing. But I think if the stuff is sellable, the incoming guy should take it. Now we just got to figure out what we're going to do. We put the limits on it. What are we going to do to protect the interest of the outgoing operator if they leave the product there? That is my 100% concern of everything.
Yeah.
I don't want somebody to get screwed out of what they leave.
I think the only thing.
And Madam Chair, in all fairness in that, I've heard it on the other side. The incoming person wants protected too.
Well, the limit would protect them.
Okay.
The limit of saying we're only going to leave you this much stuff, and we're not going to leave you stuff that's not sellable.
Right.
We're not going to have the teddy bears there. We're not going to have 15 cases of even a good product like Cheesy Ruffles. We're not going to have 15 cases there if only one case would sell in a 2-week period.
Yeah.
That's the type of stuff we got to watch. That's
Yeah.
protecting the incoming.
Yeah. And those are those are the specifics we need to make sure because somebody say, oh well, no, the rules say you got to take whatever's there. And depending on who it is, you like you said, it could be some crap. It should never been.
Madam Chair,
Oh, yes.
I have a suggestion on the
Yes.
language. I'm not going to establish a percentage, but essentially, initial inventory or an incoming operator shall not be obligated to accept initial inventory beyond X ratio of monthly sales, whatever it is. And it's because I'm thinking about turnover ratio.
Yeah.
Or not to exceed the value of 1 month's sales average over the last previous 6 months or something like that. So essentially what I'm trying to do is say, okay, if we give you enough product for 1 month's sales, and that may be too much, but if we give you that much product, and in like rest areas, that'd be way too much product. But
I would say 2 weeks.
yeah, okay, then then we'll say 50% of average sales over the previous 6 months prior to the posting of vacancy. Something like that. So you've got a tie-in that gives some protection to that incoming operator that they're not going to be obligated to accept inventory in excess of that which would be appropriate for a couple weeks worth of sales.
Madam Chair?
Yes.
So Chris, you're good with numbers. You're excellent. So is this something that you could go back on your free time, which you have none of, and do like a big use case, okay? Operator runs a Canelli. They have this much sales. This is if they have this much inventory. To the example that you just gave, to put actual examples on paper. Okay, person has a large university. They've got this much sales. Here's the amount of inventory that should be there, and but again, I think that there are nuances with that.
Yeah, it is because some people who have rest areas got a bunch of side attacks.
Yeah.
Some people who have rest areas, they may have windows, or some might have glass fronts.
Based on that facility, though.
Yeah.
So it would be based on
The
the
facility.
Do
facility.
you take like the big book or something and not names, but like facility actual examples and come up with what we call these as use cases?
Yeah.
So then I think, because again, you understand the numbers, Annette and Yvette understand the numbers, but not everyone does. And so for everyone to be able to explain, here are some actual live examples of how this would work.
Madam Chair,
Yes,
what if the outgoing operator just doesn't fill their machines as well as they should, so they're not making a lot of money, they're not, I mean, it happens. I mean, I know y'all are good operators, but not everyone is.
That's a
Yeah.
good point.
Well, and we're probably not going to be able to.
Totally foolproof it.
We can't make it.
it's too many variables and it's not going to be perfect, even if it comes up
Yeah.
with something. It's not going to encompass everything because our facilities are made up. So,
So differently.
so different.
Well, and obviously there's seasonality of facilities. One of the things that
Yes.
has occurred to me is
That's
it
true.
compounds. If I took the last 6 months of wand sales to use what I would accept in inventory in May, then I'd be screwing myself because I'm not going to sell in the summertime that way. Versus if I'm in the rest area and I'm taking the facility over in September, same scenario.
Same with
Or
university.
or if I
Yeah,
take over the rest area in April, I'm going to be essentially accepting an insufficient volume compared to what I need for kind of a liquor. But so we can't make it foolproof. But we're trying to we'll try to pick a ratio that seems appropriate.
And Madam Chair,
Yes.
I believe it should be when you're putting the vacancy announcement together, that's when the folks who create the vacancy announcement, the local and the area manager, the consultant, and the outgoing operator, the people who are helping with those things now, all get together and kind of help make that determination. Is this seasonal? Is this let's try and figure out what a 2-week inventory would, an appropriate 2-week inventory, if we land on 2 weeks, would look like for this facility. And you put that down as the expected initial inventory as part of the vacancy announcement. So then you can kind of figure it out beforehand. And so then that kind of takes care of that maybe.
But when we're talking about existing operators going to another facility, when you had that part in there where they are just going to have to, when you bid on something else, you're going to have to show that you have the means, and we're talking about
I don't
something
like that.
already established.
No, Madam Chair, I don't like that. I don't know how you establish that you have the means without sharing all of your, I mean, what, you're going to show your bank accounts to the selection panel? I mean,
If so how would you prove that you can?
and
I don't know.
And I don't, I'm with you on that, but
Madam Chair, proving you can pay it and actually paying it is two different things. too.
Okay.
So
I'm thinking,
I just,
how would we go about?
I don't know
when
how to
we put our
protect the
bids
outgoing.
out, and someone's moving from one location to the next. Okay, now they're responsible to provide inventory for their new facility. We don't want them to get in there and then they don't have, you know what I mean? Because
Then
now,
you get a cash flow problem.
yeah.
yeah, I don't know how to do that. And I don't know how to protect the outgoing person
Mhm.
if they leave product there. That's where I'm getting stuck. I'm trying to figure out a way to, and I know we all are, trying to figure out a way.
Well, I
to
thought the outgoing person should be getting paid by Christy didn't like that, the 2 week,
No, they couldn't do it that way, they said.
yeah, the Bureau paying them.
So if it's truly between operators, I'm trying to figure out how to protect the outgoing for the product
Yes.
they leave. And unless there's a guarantee that VR will cover it for the incoming, and the incoming has to take what's there as long as it's within that formula, that's the only way I can.
Will VR pay?
They won't pay for, if someone has to have an open case, which we did talk about fast tracking and all that. That's other stuff we'd have to talk about. But there's only certain situations where they can open a case.
Well, listen,
You almost have to have a promotion. So if you actually take a location that makes less than what you used to, which some people do, they want to slow down and.
we talked to said that if you're in the BE program, your case, it stays open.
No, nope, 9 days it closes.
Oh, really?
Yeah, 90 days after you have like secure employment.
I thought one of the states we talked to said that though, that if you're in the program, it was a gentleman. Who was the gentleman we talked to? It was a gentleman that we talked to from one of the states, Christy, that he said if you're, they have a VR person in the BE program working with them, your case stays open.
I think you have to open up the
Madam
case.
Chair.
You have to open up the case.
I would think you'd have to
Madam Chair.
open one, but Frank is asking for the.
Yeah, go ahead,
gonna
Frank, I'm sorry.
I was going to say, I believe it was, is the gentleman's last, I think is it Lockett? I want to say that was from Indiana, but I'm doing that from memory. I thought that's
You
where
remember
it
that
was.
too, Frank, right? You remember him saying
Yeah.
that too, didn't you?
Yeah, I think it was from Indiana, but I'm not positive, but I'm pretty sure it was. That's because I think he said the way they were able to do that with VR is they had somebody working within the BE program, or at least a liaison or something with VR that worked with them to be able to get the stuff. I don't know if I want to use the word fast track, but it was something along those lines to where they didn't have to go through and
Opening
go
their
through the
case.
counselors and everything.
Yeah, I
Right.
remember.
And Madam Chair, we did talk about that. He talked about having one counselor assigned to BE operators
Yeah.
so that they would be, it wasn't reinventing the wheel every time a new counselor came
Exactly.
around. One counselor would be very familiar with the process. So whenever an operator needed this done, and being able to quote fast track it because your eligibility assessments and all that wouldn't need to be done. We already know everybody's blind. We already know we're all eligible. We already know that they're not doing any career exploration or, none of the other things that you have to do to open a VR case. It's just a matter of opening it, paying for it, closing it.
Yeah, I think that there, if we could, that piece of it, and I don't know where we would have to go to get that piece of it there would eliminate some issues if we could mimic that part of what they do, here in Ohio. I don't know, it might be jumping a lot of hoops.
So whenever somebody, unless they wanted to pay for it themselves, which, why would they have that base? If they can open up a VR case and have their initial
That's only, yeah,
paid for them.
that's a new person though, new to.
No. Now we're talking about established operators. Brand new people, yes. Brand new people's going to get their VR to pay for it. That's,
I don't know.
but established people, what I was saying, Madam Chair, was that that's the guarantee of somebody getting paid. Is if they know VR is going
I
to
don't
pay
think
it.
that's gonna fly.
Yeah, but they're still waiting a long time to get their money.
They might have to wait a minute to get their money, but they've had to do that probably for if they have an overage too anyway.
But then every single person would be opening a case.
No, I don't
He's
think
doing
that.
really good about 2 weeks ago.
I don't like that. I would have to go to VR to get my money from a location when I
Okay.
transition over to, no.
Okay, well then, okay, bad idea. Then we got to figure out how the outgoing operator's getting paid for their stuff.
And this is from, it's two established operators. Okay.
Yes.
This is two.
Yeah, a brand new operator coming in, VR's going to pay
That's
for
taken
it.
care of.
That's
Two
easy.
established operators, one's leaving out, another one's coming in.
Yes, which is the majority.
It would have to be, somehow they would have to have the money or be on that payment plan, and in the 2 weeks, and have to pay the bureau back. That's the only how, and the bureau pay the outgoing, and they pay the bureau back if they can't pay it up front. That's the only thing I can think of.
The Bureau's idea, and it would work in some cases, and if they forgive all of our inventory up front, right?
Yes, we're all at zero.
And everyone's at zeros. So their notion is, well, we're forgiven that, so you should just leave money there. That's not going to work.
No.
And I'll give you an example. My own place. I have a $2,500 initial inventory for 27 vending machines. So nowhere near. And if I only left $2,500 there, there's emptiness all around. So that it's not going to work just to leave what
I've got zero.
Yeah, that's in Madison. Madison, I have zero. So yeah, there's nothing. I mean, so we need to figure out a way to, and people won't do it anyway. I'll be honest, but even if it was 10,000 and plenty of inventory and you were forgiven,
Of course.
people's not going to
Just
just.
take the money and run.
No.
They are. It's just not going to happen.
Right.
So we got to figure out how that outgoing operator is going to be assured of getting paid. I think if we answer that question, then we can move forward.
So, Madam Chair,
Yeah.
Go ahead.
the vendor couldn't get the incoming operator couldn't get VR to buy it, and then turn, if they have the money and we all know how much the outgoing operator, what the inventory is and everything, they couldn't just use money provided by, if VR is purchasing it or helping with it or however that needs to be done, that transaction couldn't be conducted that way, or am I confused?
No, that's not the new person. We're talking about two established, because initial new people, they're covered. But you were talking about two established operators.
And Madam Chair,
Okay.
somebody could go if they didn't have the money. They could go, especially if it's a promotion. If they're going to a facility that's going to make them more money, they can reestablish a case. They can open their case up, and they can get VR to help them with it. And nothing wrong with that. The problem is VR won't do it unless it's considered a promotion, a job save, which it wouldn't be because they already had a job. If they're saying moving down because they want to semi-retire or to an easier facility, or if it's a temp, and that's a whole other issue. If it's a temp, VR won't touch a temp.
I think right now we're getting messy. That's the
That's the problem. That's the problem. It is messy.
But we're constantly coming to VR with everything.
So the temp, it's on the SLA, not VR. A temporary, we're going to set up brand new facilities. Has nothing to do with VR. So where it gets messy is where we're talking about the facility versus individual operators. We are responsible to establish brand new facilities and sites.
Mm-hmm.
We are.
So you can use federal dollars for that with no clawback risk.
We can't, it's still a bucket that I don't think it's set aside, it's DUI and that, but we are responsible. We're 100% responsible. But to your point too, Chris, I think then what happens with the temp stuff? Is that owned? Again, this is where I get confused too, because then you have the transition of it is a person. It's not just that. And do the temp ones, and maybe we get clarity from RSA, do those, can those remain facility owned product until it's transferred and gifted to a permanent operator? I don't know. So what I'm doing, I have some questions that I've been getting. I took out the graphs of the money thing, but we can talk more money if you have questions. But also the TAC. I really want everyone to read the TAC because it gives you scenarios. Because the other scenario we haven't talked about is what happens
You
when
send that out?
I'm sending it out.
Okay.
What happens when a person retires? And again, they can't take their product with them. They should get paid. They should get paid and be whole.
Yes, they should.
And that's why I think the incoming should be responsible overall on, and it's less people having to move product and all that, and how I understand most states work. It's the incoming that pays the outgoing for the product.
I don't have a problem with that. And that's the way it should be. It's just that how can we guarantee it?
Yes,
That's where we are.
that's where I am too. I don't have a problem with it either. In theory.
The basic.
But
I think we just need to figure out how we can guarantee it.
Right. And again, there are other rules too that this could affect that, if someone, either brings a cashier's check, fails to pay, they lose 5 points on another selection, or they're on a PIP, or there's consequences to that. I'm just saying, it would motivate people to
If I had
do the right thing.
$15,000 and you gave that guy 5 points on another selection and I lost $15,000, I don't care.
I know, but I'm just saying that there should be consequences which
should be.
would incentivize people not to.
Exactly.
Juan, we have like 3 minutes, but Juan, you haven't talked and you have great experience, and I know you've tried to talk a couple times. It's hard to get word in edgewise with this group, but do you have anything to add? Because you do have great insight, being kind of new, and you chose to take on the inventory yourself. Do you have any insight that you want to add?
Yeah, I just think procedures need to be set up. It's going to be very, very.
Policy.
Yes.
Policy.
It's just going to be very muddy because you're dealing with individuals that want to do things different ways.
Mm-hmm.
But I know I took that $10,000 out and in August. By October, I had you guys paid off and I had all my debt paid off.
Now, I'm sorry to interrupt you, Juan, but that is also, I told you I went to a seminar a long time ago. Letting our operators and people know we need to have up for mobility, let them know all of these things out there, opportunities for them to be able to do stuff like that. Be able to go.
SBA help.
Yeah. Well, they have, like Heartland Bank and all this. I went to a seminar that had all these, there's different things out there that help you with your business. And it is a lot of people. Yeah, it's an SBA. It got 0.1% interest. I mean, there's different things. I mean, and Juan would be a great person to even share what he did.
So, Madam Chair, I agree, and we can do that. But so far, and I've had even a veteran operator and a lot of other operators in the past have said, why would, how we've done business, why in the world would I ever get a business loan with interest when I have an interest-free loan for life with the Bureau? What would motivate me to ever have
The
to
Bureau stopped paying inventory.
Yeah, that's it.
Well, you no longer have that.
My main point was the transition of being left somebody zero,
Yeah.
very little. You know what I mean? That was my main point. Then when I started up to the new hospital, I was like, "Would you need that? Do you need money?" No, why would I take more money from you guys?
Right.
When you've already helped me enough, where I'm established enough where there's not too many things that I can't pay for. Yeah, there's not too many things that I can take on that I'm not going to get.
We all feel the same way, but not like the problem is we have those who don't.
Yeah.
That's
Well, and it depends on the net for the facility. I mean, if they're living hand to mouth, even if they've got a facility, if they're employed,
yeah.
but they're on a if they're on a $35,000 a year net facility,
I do agree.
They have not the resources to save.
I do agree. That's
And
why
I mean, you were fortunate in that you came into a pretty lucrative facility off the jump.
Yeah.
But many of our
not
people
every
aren't.
yeah.
Madam Chair, I also recommend, like, if you guys know people in other states, operators, reach out to them and ask them. Like, I feel like sometimes we just completely reinvent the wheel when we can borrow from other states, the good, not the bad.
Yeah, there's a lot of
Yeah.
that.
I think that might be helpful too. And to ask other states and other operators, how does it work?
Yeah.
Is there conflict? Well, how do you get away from conflict? Has there been an issue where people haven't gotten paid?
I think it starts though, Christy, with a policy and procedure. We have to get that as well. We're gonna have to do this. If we're gonna do this, we're gonna have to consensus.
Still think that we need to work on, we're on a time clock with the rules. So the rules can be broader, but then the rules could also point, right, Brian, to procedure on transitions, procedure on inventory. It could refer to that, but at the same time, we could be forming the procedure as well.
Mm-hmm.
But the procedure should be more prescriptive in the rule, and we'll have an easier time to change. Like, let's say we decide to do what Chris says, and it's or 2 weeks.
Yeah.
And RSA approves that, and then 6 months down the road, we're like, oh my gosh, 2 weeks isn't enough, or, we want to go to 3 weeks. That'll be easier to change. We wouldn't want that in the rule because it'd be harder to change, but in
Procedures of policy, yeah.
Right. That makes sense. And
Yeah.
Madam Chair,
Yes.
I move to adjourn.
Do I have a second? Did I have a second?
Second, Chris, up.
Adjourn.
Yeah. We'll meet in 2 weeks again for this, or maybe next week we'll get into it, though.
Yeah, if we have time. I
Yeah.
don't see a lot on next week's unless somebody called me with more, we probably have. I think we
You know,
have
that
one meeting.
BOH thing.
Somebody will bring a unique insight that'll help to clear all this mud out.
Oh, yeah, that'd be great.
Yep.
Why?
Yeah.
Did you leave out? I haven't met you. How are you? Did I meet you?
I think, did you have the